They're all here. Great. What a conscientious group.
Thank you. I do have more info. Well,
Give me a sec. We'll get on the record on several things we need to cover. Got to mute myself first here. There we go. Okay, before we go on the record, do you both have the Zoom link for today?
Yes, I.
So you can log in. You should log in before the jurors come out, just so your machine can be connected and we can shut off the echo loop if there's an issue with the speaker. Great. All right, while you're doing that, we'll get on the record. Now that our court reporter made it through the fortress. We are here on 2023 CV 386-362. It's Christopher Pope versus MARTA. Mr. Pope is here. He is pro se. Ms. Lewis is here representing MARTA, and MARTA's agent, Mr. Ennis, is here as well. Yesterday, we picked a jury very efficiently and then went through a lengthy discussion on motions in limine that MARTA had filed. I asked for jury charges. It looks like both sides have gotten them to Ms. Niles, so she can work on a draft jury charge that I'll circulate once she's done. We left hanging a couple of questions that the two sides were going to work on over the course of the evening that I want to revisit. And let me do that so we've got a good view of the courtroom. And we had one development with a juror that I'll discuss with you all in a moment. Let's start with, in no particular order, medical records. Mr. Pope, did you get to Ms. Lewis the medical records that we were discussing? And I appreciate it may have been the second time you think you sent them, but my request to you was to identify where in your exhibits or at least your intended exhibits, you had medical records that you were thinking about admitting. Make sure you got them across to Ms. Lewis. Did you do that?
Oh, no, sir.
Okay, how come?
I didn't, I may have thought I sent it to her. No.
You thought last night you sent them to her?
Yeah, after I checked, I didn't send it. You know, I thought it was a part of my exhibits.
Okay.
Yeah.
I just want to make sure I'm following. You understood yesterday when you left that I had asked you to send them to Ms. Lewis.
Yes.
Okay, but you did not do that.
No, after I checked, I'm saying the exhibits I sent, I looked over them and it wasn't a part of it.
Oh, you went and looked through all the things you had previously provided. They weren't in there, so you're backing off those.
Yes, yes,
Okay,
sir.
got it. So no medical records. Again, that doesn't mean you cannot talk about what you experienced.
Oh, yeah, yes,
We've been
sir.
real clear about that. You can say, I went to a counselor, I went to a doctor, where there may be objections that I would likely sustain would be if you start getting into what the doctor told you.
Right, right.
Okay, good. Anything, Ms. Lewis, you want to get on the record concerning medical records given Mr. Pope's announcement? Next topic was union reps / shop stewards. And that was of interest to me because we were working through the relevance of Mr. Royal's testimony and Mr. Gresham's testimony.
Sorry, I just want to invoke the rule again. I'm not quite sure.
Are you Mr. Gresham? Hey, Mr. Gresham, good morning, sir. So unless Mr. Pope has released you as a witness, I need you to wait outside. He will get you soon because he's going to be able to start calling witnesses probably about a half hour or so after we get the jury in here, et cetera. If Mr. Pope has told you you're not testifying, then you're welcome to stay in here. Mr. Pope, what is Mr. Gresham's status?
Oh, yes, he's testifying.
Okay, then we're about to talk about you and your testimony, so I need you to step outside. Thank you. Thank you, Ms. Lewis, for flagging that. So we discussed yesterday afternoon the connection that Mr. Royal and Mr. Gresham might have to Mr. Pope's situation. And what I thought you said to me, Mr. Pope, and I may have misunderstood because I was learning new terms like see me sheet meeting or show me sheet meeting, all these terms unique to life as a MARTA employee. But I thought you told me that Mr. Gresham and Mr. Royal, along with being maybe friends and coworkers and whatnot, they could talk about your situation and your complaints against MARTA because one of them, maybe not both of them, but in different sessions, each of them had been your shop steward or union rep when you had the disciplinary meetings or the show me sheet meetings with MARTA people. Am I remembering correctly that that was their connection to your situation?
Yes, Mr. Royal won't be here today.
Okay, you've excused him?
Yeah.
Okay. All right, so we're back to Mr. Gresham, who is here.
Mr. Gresham, who's here?
Okay, and you're saying that he was present for one or more of the show me sheet meetings you had?
Well, he present to testify.
Okay.
Same as Mr. Gresham, but for personal reason, he's not. From my understanding, he's not coming.
Mr. Royal's not coming.
Yeah.
Well, Mr. Gresham's here.
Yeah.
And if you're going to call him as a witness, I need you to tell me not every word he's going to testify to, but what's he going to talk about generally?
He's going to talk about his service with the company. I have questions.
I'm sure you've got questions.
Pertaining to medical, anything medical.
Pardon me?
It's not pertaining to anything medical.
Okay.
I understood you yesterday when you told me.
Good. And we got that part. But another thing I told you is that it would not be proper testimony for Mr. Gresham to come in to say, hey, I got mistreated too. I was passed over for promotions or I didn't get a raise. And I think it's because I was older or I was male or whatever discriminatory intent he thinks MARTA had. This isn't his case, it's your case.
And you told me if I say it, she'll object to it, and you'll object to it.
Well, I won't object. I will exclude it. But tell me what he's going to talk about your situation, because his situation. Let's say he honorably served MARTA for 100 years, and he got a gold watch and this and that. That's not your case. That's his situation.
He can talk about the criteria when it pertains to job promotion.
Okay,
Yeah.
So he's going to help educate the jurors from his perspective on what it takes to get a promotion, et cetera.
Yes.
He's sort of I'm using this word unofficially, so don't jump out of your seat, Ms. Lewis. He's sort of your expert for the jury, for them to understand how promotions work and how you get evaluated. And he'll be looking at it through the union lens because he was or is a shop steward. Is that a fair summary?
Yes, and he'll be looking at it through and just an employee, been there 40 years.
Okay, all right. Ms. Lewis, assuming that is the main area that Mr. Gresham covers, that seems relevant. And he'd be subject to cross-examination in case you find his testimony to be inaccurate because he might not be the supervisor who would be, or the committee that would be making promotion decisions. But it sounds like he would be qualified to explain to jurors how that process works, given his history and connection with MARTA. Your thoughts about that, if that's what Mr. Gresham is limited to?
I will subject him to cross-examination, Your Honor.
Okay, and you will certainly be able to do that. I just want to avoid a scenario where you're objecting each question. If Mr. Pope stays in that turf and he establishes that Mr. Gresham has a basis to answer the question, so they're not speculative, things like that, that strikes me as germane to this case and Mr. Pope's complaints. But I think it's important that we're previewing it so you know what's coming. You've had notice that Mr. Gresham was a potential witness and you explained you chose not to depose him. So I feel comfortable going forward that way. I just want to make sure you understand and are not wanting greater clarity before we dive into that.
Well, I don't want to waive any basis for objection with regards to him. I'll be very transparent, Your Honor. He has absolutely no qualifications to speak to promotions as it relates to a journeyman ET, which is what is alleged in this amendment.
Okay, I hear you, and I'm not in asking you, are we gonna be able to go forward with this? You waive nothing at all. I just want to avoid setting up, for example, if what Mr. Pope said is that Mr. Gresham is going to talk about my medical condition. Right. You, I suspect right now, would say, no, I object holistically to that area of testimony. I don't even want to cross-examine him because he will be providing hearsay, things outside his area of knowledge, et cetera. Which is why I asked Mr. Pope in advance. What Mr. Pope has described sounds like a space in which Mr. Gresham might be able to operate, subject to cross-examination. But I just didn't want you suddenly moving for a mistrial because Mr. Gresham said, hey, I've been with MARTA for 40 years. Here's my understanding of how X and Y works.
No, not mistrial basis, Your Honor. I just want to make the court aware that any testimony outside of real services, I think is fair game for objections because that's just not within his scope based on his experience.
We'll hear what he has to say about it and what you have to say about it. But it sounds like Mr. Gresham is a go.
Yes.
Obviously, you can testify. So we covered that. We covered Mr. Royal. Mr. Pope, was there anything else you wanted to go over before I bring the jurors in?
Oh, yes. I wanted to question her witness, Mr. Enos.
Yeah.
I want to call him to the stand as well.
You can call Mr. Ennis. He's here. So you're able to do that?
Okay.
Okay.
So why is not he ain't out there?
Well, we talked about that yesterday. If you had a lawyer, you would still be able to be in court even though you're going to testify because you are one of the parties. You are Christopher Pope. So obviously you're here. You're representing yourself. But if you had Sally Smith as your lawyer, she'd be sitting here and you'd be sitting here. And Ms. Lewis couldn't say, well, wait, Pope's going to testify. You're a party. Right. Well, MARTA doesn't exist as a human. It's a corporate entity. It is allowed to appoint an agent, and that agent gets to stay in court for the entire trial as MARTA's representative. And they have designated Mr. Ennis as that person. So they've got a lawyer, just like you could have a lawyer. You're choosing not to have one. So it's lawyer plus party, and Mr. Ennis is that person. They could have selected someone else. It could have been the CEO of MARTA or the chairman of the board or this or that. But Mr. Ennis, it sounds like for good reason because of his knowledge and expertise, he's the agent because he can lean over to Ms. Lewis and say, this is what a journeyman 7 means. And she might not know that, but he can help educate her on that. Right. And he may well testify, but you can call him as a witness.
Yes, sir.
Okay. Anything else from your side?
Oh, no, sir.
All right.
Thank you.
Ms. Lewis, anything from MARTA's side?
I think that curious at all, Mr. Royal is not testifying, so we don't need to go through the documents that I reviewed last night.
Correct.
And they said obsolete, and, we've addressed the medical records, so I believe that's it.
All right. We received an email that I'll make part of the record. It will be Court's Exhibit 1 from juror number 1, meaning she was number 1 in the pool. She's also the first juror that you all ended up selecting. I'm going to read it, and then we need to talk about it. Dear Ms. Niles, thank you for the notice regarding my selection as a juror for the Pope versus MARTA case. I wanted to disclose that I have a personal connection to MARTA that may be relevant, but I wasn't 100% aware of how close until I ran into her on a jog this afternoon. Clearly, jury selection did not last long enough because she was out jogging. A close friend, comma, neighbor, comma, and client of mine, and then in parentheses is the name. It's Heather, and the last name is spelled L-U-Y-K. I don't know how you pronounce that. I'm going to say Luke. Heather Luke currently serves both the chief of staff and chief legal counsel at MARTA as program manager. While I am not personally connected to those individuals, I am closely connected to Heather, and I wanted to be transparent about this relationship in case it presents any concerns regarding impartiality. Please let me know if any additional information is needed. Then she said, I'll be here unless otherwise notified. She sent this at 8:30 last night, so I didn't reach out to her. She's here. I'm gonna bring her out in a minute and ask her a few questions, thank her for this disclosure, and ask her a few questions about it on the record, and I'll give both sides a chance to ask her questions. I appreciate her disclosure. I don't think it is disqualifying. Just the fact that she is a friend and neighbor of Ms. Luke, but we'll need to see how she thinks that would affect her ability to hear this case, if it would affect her at all. You can be neighbors of people who are connected to a party in litigation and still have a very, very open mind. So that's my proposal. Mr. Pope, any objections to handling it that way, bringing juror 1 out, asking her a few questions about this email?
Oh, no, sir, no objection.
Okay. Ms. Lewis, you okay with that approach?
I have no objection.
Okay. Does this name Heather Luke or L-U-Y-K, does that ring a bell? You know who this person is?
I do.
Okay. And she is a MARTA employee?
Yeah.
Okay. I just wonder, we could really short circuit it if you're like, she worked there 100 years ago, and
Oh, okay. No.
that's a real MARTA person.
Mhm.
Okay, all right. If you could get juror 1, Ms. Richardson, please.
And Judge, I didn't do this before we bring them out and start. I'm gonna need a brief moment because this is not the case that I was here for.
Oh my gosh, what case were you here? Oh, were you here for Archer versus Roldos?
Yeah. What
Yeah.
happened?
It's number 2 to this, and so this went out. So did you all, you were wondering why magically there was a court reporter here? Yeah, nope,
I would love to be.
Yeah.
The courtroom is amazing.
thank you.
But,
No, you should take your time. I mean, feel free to shut down. They need to pay you for being here today because they,
If you want to stay, you can stay. MARTA will pay you.
how about, let's work with juror 1 and then you guys sort that out. Okay.
After this. and then-
Good morning.
Good morning.
So this court reporter was here for a different trial. And she said, wait, you're talking about MARTA? I thought this was Archer Restoration. That's a case that is after this one. Thank you for your email. Ms. Niles forwarded that to me. I've talked about it with Mr. Pope and Ms. Lewis. And I want to ask you a few more questions, or a few questions about what you shared. Remind me your profession, because first of all, how do you pronounce this person's last name? Is it Luke? Like? Okay. Ms. Like, you mentioned was a client of yours, and I couldn't remember what that means. If that's like you're a chiropractor or you slice meat for her, or what is it you do? Interior design. So you make her house look nicer. Okay. And is that your connection? Is that, it's professional, or you guys are also neighbors?
We're also neighbors. She was a roommate with my sister-in-law, so like I know her well. We don't like catch up about work. But when that run-in happened, I was like, that's significant. I should probably let them know.
Got it. When you say run-in, not like she accosted you and said, hey, you better do this during the, I know you're a MARTA juror. You're jogging, you saw her and the light bulb went off. Okay. Tell me how often you and Ms. Like discuss her job as a program manager.
Rarely.
Okay. What do you understand her job to be?
I didn't know her job title until yesterday. So I thought it was communications.
Was she wearing a badge that said program manager, or how did you learn her job title?
No. When we ran into each other, we were talking. And I told her that I was going to be here tomorrow. And I was like, oh, wait, what is your scenario? What do you do at MARTA? And then she told me.
Okay.
And I was like, I didn't tell her the nature, but when I was telling her I was coming here tomorrow,
Okay.
it clicked for me.
And did she indicate that she knew anything about this litigation?
No, not at all.
Okay. And so really yesterday was the first time you knew what her job title was.
Yep.
But if you had bumped into her 3 days ago, you would know you work for MARTA. I think you do communications.
Yeah.
Okay. And it sounds like your connection with her isn't professionally because you did interior design for her MARTA office, but it's professionally because you did things privately in her personal home. Okay, got it. Do you have any concerns, Ms. Richardson, that your relationship with Ms. Like would cause you to be anything other than neutral coming into this case? All right. Mr. Pope, do you have any questions for Ms. Richardson about her connection to Ms. Like, or anything about her neutrality coming into this case?
Oh, no, sir.
Okay. Ms. Lewis, anything for Ms. Richardson? All right. Thank you again for the disclosure. It was the right thing to do. We'll get you all out here in a second. All right, we're going to go off the record for a moment, and why don't you guys talk business? Mystery court reporter and MARTA, do you have a card?
I do.
Okay. If you're staying, I'll take it. If you're not, don't waste your card.
Well, I have plenty, so it's not a waste.
Okay.
When is the Archer still going forward?
So we're giving them an update. We're giving them an update at lunch. It depends how far we are in this at lunchtime. Because if we're not far enough along, then we're not doing Archer this week, which means it'll be in August.
Ah, gotcha.
But it's the Roldo side that's pushing this, and they are pushing it. Hey, we got calls yesterday.
Yeah, defendant wants jury trials.
Yeah. Well, he's kind of plaintiff now because all that's left are his claims against Archer. Archer's claims some mean judge threw out. So,
Were you that mean judge?
I'm the nice judge who threw out their claims.
Okay, so how long is this trial scheduled?
It'll be today. Tomorrow is a half day. We start at 1 tomorrow, maybe into Thursday. That would be it.
I might want to call my office and just let them know that
You're pivoting. Why don't you call? Because we got the jury ready to go. So feel free to reach out. You can sit right there if you want to. If you're welcome to step outside if you'd rather do it, if they have to speak in code or something.
not go, just straight to figure out what.
Okay.
I'll be right back.
I have a question.
As long as it doesn't need to be on the record.
It doesn't, it's more logistical. How do you handle a motion for attorney's fees? Do you have a separate hearing post-trial?
So, as in like a 9, 15, 14? Yeah, that would be post-trial. That's not a jury question.
Right.
We would deal with that post-trial, depending on the outcome.
Of course, just planning in my head.
Yep.
Needs to happen.
Okay.
Thank you.
So, Mr. Pope, we're going to sort out this court reporter situation, and then I will bring the jurors in. I'm going to give them some basic legal instructions, And then I'm going to turn to you to see if you want to give an opening statement. You told me yesterday you were going to do that. So you'll be free to do that. Just keep in mind that your opening statement is not testimony, nor is it argument. It's basically a preview of, hey, this is what you're going to hear about.
Yeah.
And then we'll see if Ms. Lewis is going to give an opening statement, and then you're into witnesses. So sounds like you've got Ennis, Gresham, and you. You can call them in any order. And we will keep going until lunch. We'll take a morning break, assuming we get started soon. Lunch will be just before 12:30. I have a online meeting from 12:30 to 1:30. So we'll go till about 12:20, unless there's a natural break a little before that. Okay?
I have a question, sir.
Yes.
If my document is not showing clearly on the screen,
Yep.
the Zoom, is there any way I can actually show them the document?
So two ways, yes. You can always, as long as it's been admitted, so you don't just hand something to them, but hey, I'm tendering plaintiff's exhibit 9. And if it's admitted, then you can put it on the screen. You don't put it on the screen till it's been admitted.
Okay.
If it's blurry that way, you can always hand the exhibit to the jurors and they'll pass it around. The downside there is that they'll not be paying quite as much attention as you keep going. Whoever's got it's going to be looking at it, and then when he hands it over, they'll be plugged back in. Or we have an overhead projector that sometimes works, and you could try doing that. So if your Zoom thing isn't working real well, when we take the morning break, you may want to experiment with the overhead projector, because that's another way to get something up on the screen. But worst case scenario, you can always hand something to the jurors. But what I don't do is say, all right, we're going to pause while each juror takes a look at it. We just keep on going while they're handing it around. Okay? Anything else?
Oh, that'd be awesome.
All right. You sit there for a sec so we can make sure the monitor's at a good angle. That's pretty good. You look all right today.
You don't look great.
You are getting a little gray. That's called legend. All right. Oh, let's do this. That last second. Freshen that up. Can you go check with the court reporter? Because she either can or she can't. We got to roll. What's the word?
They said that I can stay. They're gonna create a, did anybody have a notice? I can just get like a quick picture of the caption to send
Sure.
them? Since I have literally no information about this.
So it's number 3. Realized Ms. Lewis had this deep pocketbook. She's like, great, you're on board.
Deep.
Cause it will be, usually, well, I have had a couple of pro saves that share and take one, but if we all want you, I'm assuming.
Well, I'm on Marta.
Well, yeah, but you're Marta.
Yeah.
Yeah. No, this is a request from defendant right now. Mr. Pope can decide later whether he wants to plug in.
Yeah.
Okay, let me send this one
I'm
on.
fine with that.
And update my sheet so that I'm looking off of the right information.
All right, are we good? Mr. Pope, you ready for us to bring the jurors in?
Oh, yes, sir.
Great. Ms. Lewis?
Yes, ma'am.
All right, let's bring the jurors in, please.
I just need a rest.
All right, the jury. Judge President, county floor.
Thank you, Deputy Gordon. Everyone can be seated. Good morning, ladies and gentlemen. Welcome back. I appreciate you all being on time. It is the exception that on morning 1 of a trial, we get all our jurors here on time just because you're figuring out a new routine. And the city has decided to throw up about 400 different obstacles if you're coming off a major highway to get downtown. almost every street around the courthouse has been narrowed to one lane because they're putting in these, well, it's a MARTA thing, so we won't talk about it here. But the roads are special downtown right now, and I appreciate people being on time. The lawyers and I had to, or the parties and I had to work through a few things before we could bring you out here. Generally, we try to do that before you get here, after you leave, and during your breaks, but things come up. We are ready to begin the trial. Before we can do that, I need to give you some basic operating instructions and talk about the law a little bit, and then I'll turn to the parties to let them give their opening statements. From here on out, when you come to the building, you report to the jury room. And when we break for any reason, you go to the jury room first. If it's a long break, you can leave the jury room to go out into Atlanta and come back, for example, at lunchtime. During the shorter breaks, we'll have usually a morning and an afternoon break that are intentional, i.e. I say, let's take a break, as opposed to something organically pops up during trial. During those breaks, you don't want to go too far away because they're usually only about 10 minutes, but you should know that this hallway is a private hallway. You're welcome to fan out down that hallway if you want to see actual daylight. There are windows at the end of the hallway. But it is judges' chambers all the way down. So don't go down to the end, crank your phone up and listen to heavy metal, because one of my colleagues will come yell at me saying my jurors are creating a ruckus. But it's fine to be on a phone call outside the jury room, so you're not polluting the jury room with too many calls, and just use the hallway for those phone calls if you have something you need to do during the break. If you have logistical questions about anything, it's too hot in the jury room, or is there an additional restroom, or where's a vending machine? Everything flows through Deputy Gordon, or if he happens to be on the break, whoever his temporary substitute is. But Deputy Gordon should be here for the duration of the trial, and he is your point person for where is this in the building, where is this outside the building. It's not appropriate for either of the parties to interact with you during the trial outside the four walls of the courtroom. So you might be walking down an external hallway and there's Mr. Pope or Ms. Lewis, and they're going to look at you and walk away. And that's not because you're ill or they're ill. It's just not appropriate for them to be interacting with you. You can imagine how it would look to the other side if three of you are laughing it up with one party and the other comes walking around like, well, what's this person talking about? And the answer is they shouldn't be talking about anything with you. So your innocuous question might be, which way is the elevator? And the litigants here need to not engage you in that way. So don't ask them. I don't think you'll bump into each other, but in case you do, they are behaving appropriately, even though it may seem awkward if they shun you, except when we're in the courtroom, and then they will be engaging with you. We will go roughly 9 to 5 each of our days that we're here, except tomorrow. So it may be one day we're 9 to 5, and the only other day of trial we're not 9 to 5. I'll talk about Wednesday in a moment. But for today, the plan is to end around 5. It's not a hard stop. It's not that the lights go out at 5. We may finish with a witness at 4:40. It may not make sense to get that next witness on for just 15 minutes because that makes it choppy, and so you leave a little early. We may be in the middle of a witness as we're approaching 5, and I'll ask the person who is asking questions, when do you think you can finish? And if we get a reliable estimate, like, hey, I need 10 more minutes, we might go to 5:05. Hopefully that doesn't interfere with your evening schedule, but we don't go to 6 or 7 or 8 just because we're in the middle of something. As I mentioned, they're the fixed breaks of a mid-morning, lunch, and mid-afternoon. If at any point you need a break, you've had enough, or it's just time for the restroom, or whatever it is, let me or Deputy Gordon know. You can raise your hand, do whatever you need, and we'll stop. It is important that you all be focused throughout the trial. There's no rewind button, and you will not get a transcript of witness testimony. So if you start to fade, let me know, and we can pause for what would be a shorter break. I'm not going to give you 15 minutes, but it could be long enough to just walk down the hallway or get a snack in the jury room, and then we will reconvene. Before I give you the legal instructions and a few procedural overviews, I need to administer the juror oath. Yesterday, you got the potential juror oath, but the real deal is now. So if you would please stand and raise your right hand. Do swear or affirm that you shall fairly try this case and provide a true verdict according to the law I give you and the opinion you form concerning the evidence to the best of your skill and knowledge and without favor or affection to either party. Please say yes if you so swear or affirm. Yes. Does anyone not so swear or affirm? Okay, thank you. You are all officially jurors. First thing, the notepads that you have are for you. You are free to take notes. You are not required to take notes. A few things about the notes you take. One, they are private until deliberations begin. You actually don't get to talk about the case until your deliberations begin. So you may go to lunch as a group or as subsets, and you can talk about anything you want at lunch other than, hey, what do you think about this so far? The other side, this side, it's not proper to do that because you don't have all the evidence. And importantly, you don't have the law that I'm going to give you that you have to apply to the facts as you find them. And so you can't really know, well, this side's doing better because you don't know yet what the elements are of the claims and what it is that one side or the other needs to do. So don't talk about the case, and that means keep your notes private. Your notes are a memory aid so that when you are deliberating, you're free to say, hey, I wrote down that so-and-so said this. And your neighbor can be influenced by that, but your independent recollection is what ought to guide you, as it may be assisted by what's in your notes or a neighbor's notes. Your notes will be destroyed at the end of the trial. So if you write in there, McBurney's a jerk, I'll never see it. We literally put it in a shred bin when it's done. No one goes through it to admire the sketches you've been doing or anything like that. Don't let note-taking distract you. You are not able to take down everything that people say. Write down what to you, if you're going to write anything, might be a highlight of testimony or an event or this or that. One of your roles that I'll discuss in a moment is deciding or determining the credibility or believability of witnesses. And if your head is buried in your notepad because you're trying to write down every detail, you're going to miss important things like, why did this witness smile at you all when one side was asking questions, but when the other side started asking questions, they got sweaty and turned away and didn't engage? That might inform you as to the credibility of that witness, and you'll miss it if you're buried in your notepad. But as I said, there'll be no transcript of witness testimony, so you'll strike the right balance with the notes that you take. In a civil case, which is what we're handling, the plaintiff, that's Mr. Pope, has the burden of proving his claims. He must prove his claims by what is known as a preponderance of the evidence. You're going to hear me talk about that term a lot at the end of the trial when I give you the more extensive legal charge. The term preponderance means superiority in weight. And as it is used here, preponderance of the evidence means the greater weight of the evidence upon whatever issue you're trying to decide. To be a preponderance, the weight of the evidence must be sufficient to incline a reasonable and impartial mind, those are your minds, to one side of the issue rather than the other. And this is where that image of the scales of justice is pretty applicable. In criminal cases, it doesn't work that way. The burden is very, very different. But in a civil case, a preponderance of the evidence is enough to get you to think, you know what? I'm not neutral. I'm leaning in a direction. And if the direction in which you are leaning is the plaintiff's direction, he's met his burden. But if at the end of the trial, I can't make up my mind, I'm 50-50, that is a verdict in favor of the defense. And obviously, if you're leaning in any perceptible way towards the defense, the plaintiff didn't meet his burden, and that's a verdict for the defense. Preponderance of the evidence, enough to tilt the scales perceptibly in the direction of the plaintiff. And he's got that burden. The defense doesn't have a burden here. They're going to try to put weight on their side of the scales or remove weight from the plaintiff's side, but they don't have the burden of convincing you that the scales go in their direction. Now, the basic structure of a trial is that in a few moments, Mr. Pope will be given an opportunity to give you an opening statement. An opening statement is a preview of what one side thinks the evidence will be. I expect to hear from this witness who will tell you this, etc. Opening statements are not evidence. In fact, nothing Mr. Pope says when he's not on the witness stand, and nothing Ms. Lewis ever says is evidence. It may be argument at the end of the trial. It may be an attempt to persuade you, but the evidence you're going to receive in this case comes in two forms. One, it'll be what a witness says when he or she is under oath and answering questions. And two, it will be exhibits that are admitted. So there may be a photograph, and if that is tendered and admitted, that's evidence. You'll have that photograph with you during your deliberations, so you'll be thinking about, what did the witnesses say? That's the big bucket of evidence. And what are the exhibits that were admitted? That's your evidence, not what Ms. Lewis says or what Mr. Pope says when he's off the stand. I suspect he'll testify, that's his call. Once he's under oath and is talking to you, those words are evidence. Now, your job is going to be a little more complicated than if you've ever been a juror before in a case, or what I'll call the typical juror, because Mr. Pope is serving two roles in this trial. He is his own advocate, but he is also a party. And so he'll have the right to take the stand. And he may end up saying some things both in his opening or his closing and on the stand. And you're going to need to sift through that and say, well, let me remember what it was he said when he was testifying. That's the only evidence you'll be getting directly from Mr. Pope. Any other time he's addressing you, it is akin to what Ms. Lewis will be saying. And what Ms. Lewis says is never evidence because she's not going to be a witness in this case. When the openings are done, I'll turn to Mr. Pope and ask him to call his first witness. When that witness is sworn in and answers the first question, you'll have received the first bit of evidence. That first answer is the first bit of evidence that you've received. When that witness is done, I'll ask Mr. Pope to call his next witness. And at some point, he'll say, I don't have any more witnesses. Plaintiff rests. That also means break time for you. When one side rests, we have to take up some legal issues. You'll get a break. And then we'll move forward with whatever naturally flows from that break. But after the break, what typically happens is then I'll turn to Ms. Lewis and say, do you have any evidence to present? While the defense doesn't have a burden, they have a right to present evidence. And so Ms. Lewis may call witnesses. She may call some of the same witnesses you already heard from. Generally, I expect the two sides to get out of the witness what they need to the first time that witness is called. But the defense is free to reserve some of their questions until they present their case, should they choose to call any witnesses. Eventually, when both sides say we rest, then Mr. Pope and Ms. Lewis have a chance to get in front of you to give what's called a closing argument or summation. That's when they're really arguing. They are trying to persuade you to decide the case in their favor. And they're free to draw extrapolations and say, you shouldn't believe this witness, here's why, and here's what the evidence shows or what it failed to show. They'll be advocating, and you're free to feel persuaded by what they said. But remember, what they're saying is advocacy and not evidence. The Pope may get in front of you and say 10 times in a row, it was dark out when this happened. But if your recollection was there's a photograph showing that it was the middle of the day, what controls is your interpretation of the evidence and not one of the advocates' interpretation of the evidence. And when the closings are done, I'll give you more legal instructions as opposed to procedural instructions like I'm giving right now. During trial, both sides have the right to object to evidence or questions if they think the admission of the evidence violates some rule of evidence. And I'll rule on those objections. It's like you may have seen on TV. Someone will say, objection, hearsay. And I'll either sustain it, meaning that's a good objection, someone needs to head in a different direction, or I'll overrule it, which means we keep going in the direction that that advocate was trying to go. Every once in a while, testimony may come in that is objected to, and if the objection is successful, that advocate may say, Judge, I want you to strike that testimony. It's sort of a fictional construct. I don't have the Men in Black little thing, red light, where you can't remember what happened. But if I tell you to disregard something you heard, I mean it. So if you find that you're back in deliberations and one of your number is saying, hey, remember when that guy said that the person was wearing a green shirt, but that happened to have been one of those things where it was objected to, and I said, you have to disregard it. You need to police each other and say, I do remember that, but we are supposed to disregard the fact that someone said the shirt was green. That may seem artificial, and how do we do that? But I want to reassure you, if someone blurts something out that they weren't supposed to, that is central to your decision-making process, we don't have an objection. We have what's called a motion for a mistrial. And if it has so upset the apple cart that it wouldn't be reasonable for me to assume you could disregard it in your deliberations, then sadly, we have to do this all over again. Not with you, but with another 13 jurors. And we will all be very disappointed. But the advocates have been instructed on areas they're supposed to stay away from. I don't think there are a lot in this case anyway. So if you are told to disregard something, it's going to be pretty peripheral, like what size shoes did the guy have? And it's just not relevant. And the way it was coming in was through hearsay or something. I'll say, hey, disregard about the guy's shoe size. And you'll be all right with that. I mentioned motions for mistrial. The parties also have the right to make motions during trial. Generally, for you, the difference between an objection and a motion is that a motion means you get a break, because I need to talk with the lawyers much more openly about what the concern is and with the parties, and they may need to preview what they think is coming in and why it shouldn't. And if you're listening to them say that, it sort of defeats the purpose of trying to keep that from you. And so you may have to take a break while we work through that. Typically, we work through motions during your natural breaks, but we'll see. And just oblige us if we do need to take an unscheduled break. Now, I need to rule on all these objections and motions. Nothing I say is evidence, and nothing I say during this trial should you consider as some comment from me on the evidence, the strength of evidence, lack of evidence, or that I have any leaning whatsoever towards one side or the other. I'm neutral in this case, and my role is to make sure it is fairly tried and that the case is tried consistent with the laws of Georgia and the rules of evidence. That's the extent and impact and meaning of anything that I say during this trial. Your job is to figure out what are the facts of this case, what happened, and is what happened something that makes MARTA liable to Mr. Pope. In deciding that, you'll be considering the evidence, testimony, and exhibits, as well as the law that I give you at the end of the trial. In doing your job, you will necessarily be determining the credibility or believability of witnesses. It's for you to decide which witnesses you believe and which witnesses, if any, you don't believe. In determining credibility, you're free to consider all the facts and circumstances of this case, the manner in which the witness testified, what they looked like and how they acted while they were talking to you during this trial, the witness's interest or lack of interest in the case, and the means and opportunity a witness has for knowing the things about which he's testifying. You may believe or disbelieve all or any part of the testimony of a witness. While you're determining the facts of the case, you may find that there are conflicts in the evidence. If you do find conflicts, you should try to reconcile them as if every witness has been testifying truthfully to you about what he or she remembers about this case. Often one person will see things or recall things differently from someone else who was there at the same time. That doesn't mean one person's being truthful and someone isn't. It just means that recollections differ. If, however, you find that some parts of the evidence are in such conflict with others as to make it impossible for you to reconcile them, you should believe the evidence that seems most reasonable, probable, and truthful to you. During the trial, you will be permitted to ask questions. This is done for two reasons. One, you are the fact finders and you're entitled to as much admissible evidence as possible. Number two, you are absolutely prohibited from doing any outside research. And it is very easy these days during a break to pull out your phone, hit Bing, and say, what is da 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 da, or give me an aerial photo of this situation. Do not do that. If I learn that that happens, that is likely a mistrial, which is bad news for everyone, and it's particularly bad news for you because I promise you, you will sit through the next trial. You will sit out there and you will watch the next trial if you are our cause for a mistrial because you did outside research. It's forbidden. You must decide this case based only on evidence that's presented here in court with both sides present, a chance to object, and for me to apply the rules of evidence. But there's a cure to the curiosity itch, and that's that you can ask questions. The way you do that is by writing them down on those note cards. You'll see there are a few stacks of note cards there. Please write legibly. Only one side of the note card. You can write more than one question on the note card. But at the end of every witness's testimony, I'll turn to you all to say, do you have any questions? And you may have been writing some down during the witness's testimony. You may cross some of them out during the witness's testimony because the parties get there. But if at the close of testimony, you still have questions for that witness, you put them on the note cards, Deputy Gordon collects them. I will review them with the parties because they need a chance to object. They don't do that in front of you. And I don't ever identify which juror had which question. But if there are unobjectionable questions that you have posed on these cards, we'll come back in court. I will ask the witness your questions. The witness will answer, and the parties will have a chance to follow up. That's the way you get your questions answered. You also should not draw any conclusions if a question you submitted is not asked. It just meant it wasn't the proper question. It doesn't mean that one side was scared of the question or that you're really onto something. It just means maybe the only way for that witness to answer that question would be hearsay, and that's not something we do here. You must decide this case solely on the testimony you receive and the exhibits that are admitted. Hey, you need to take that down, Mr.
I'm
Pope?
sorry about that. Oh,
Please don't share your screen until that's all right, but until you have successfully tendered an exhibit.
yes, sir.
All right. You all, jurors, decide this case only on the testimony and evidence presented here. No visits to a MARTA station if there's a MARTA station that keeps coming up during testimony. No outside research, as I mentioned. And again, to repeat, no early discussions about the strengths or weaknesses of the case for either side. You'll have all the time you need to deliberate in this case, but you don't start your deliberations until you've heard all the evidence, closing arguments, and I've given you the legal instructions. Once the case is over, you are, of course, free to do anything you want with the information that you gleaned. Your confidentiality is just during your deliberations. There's no prohibition when the trial is over to talk about it with other people. But between now and the time you're released from your service, it's important that you not interact with others about it. It will be very natural when you get home tonight to want to vent or say, hey, here's what happened today. But you need to be circumspect. Someone's going to say, honey, how was your day? And it would be, it's great spending time with Judge McBurney. That's it. Don't go beyond that. You can get real about how bad it is when the trial is over, but well-meaning people will say, when I was a juror, that happened. Let me tell you what that really means. And that's not what it really means, because that's a different trial. It's not this case. It's not these advocates. It's not this situation. And so you have to be very bland between now and the end of your service about what's going on. You continue to serve. And until then, it's almost you're taking an oath or a vow of silence. You're just having a good time, and that's all you need to share with people. I don't believe there will be any media coverage of this case, but in the off chance you're driving home and they say, this live from a Fulton County Courthouse, Pope versus MARTA, change the station and listen to something else. Again, that would be outside information that's likely inaccurate about what happened in court, but stay away from that. And with that, I am done with my preliminary instructions to you all. And I will turn to Mr. Pope to ask him if he wants to give an opening statement.
Yes, sir.
All right, when you're ready, you can address the jury.
Good morning, Your Honor, opposing counsel, and ladies and gentlemen of the jury. May it please the court. My name is Christopher Pope, and I am here today representing myself in this matter as a pro se plaintiff. This case is about my employer's violation of my civil rights, labor rights, and my dignity as an employee. I was showed through evidence and testimony that my employer has engaged in the following illegal actions: discriminated against me on the basis of age, gender, and denied me promotions I was qualified for, retaliated against me for filing an equal employment opportunity complaint. I asked the court and the jury to consider the totality of the circumstances and apply the laws Congress enacted to protect workers like me and you. Justice demands accountability, and I am here to ensure that the truth is heard.
Thank you, Mr. Pope.
Yes, sir.
Ms. Lewis, are you going to give an opening statement at this time?
Briefly, Mayor. Good morning, ladies and gentlemen of the jury. Again, my name is Karima Lewis, and I do represent MARTA in this employment discrimination action. I want to thank you again for your service here today, and respect your time. I'm going to jump right into what the case is about. This is an employment discrimination case by a disgruntled employee who is still an invaluable employee of MARTA. He began his employment with MARTA in 2012 as a bus operator and was subsequently promoted to rail operation in 2014. Believe the evidence will show that as a rail operator, the essential duties include safely operating the MARTA passenger trains. And you would do that to pick up passengers and to discharge passengers at the rail station platforms. They're also charged with making clear and concise transit announcements at each rail station. This is one of our most safety sensitive positions, of course, because we're transporting our most valuable asset, which are our patrons. There are a number of safety policies that apply to these positions, which include how many breaks a rail operator can take and when precisely they can take that break. It's because what I believe the evidence will show, time is of the essence with regards to transporting patrons. So a lot of policies and restrictions apply to these different rail operator positions. During Mr. Pope's employment with MARTA, he has violated several of these safety initiatives and policies. Because of that, he has been disciplined. Some of those violations, as you will hear in evidence, include occurrences. Occurrences will be defined as no-shows to work or tardiness to work. He has been disciplined for failure to follow instructions. Of course, in these positions, when transporting patrons amongst the MARTA rail lines, following instructions is very key. Lastly, he has been disciplined for conduct unbecoming of an employee. And that is for name calling, conduct that is not conducive to a safe and healthy work environment. Because of these disciplinary actions, Mr. Pope has taken it personally and has asserted that the results of these disciplinary actions constitute discrimination. What I believe the evidence will show is that MARTA has made every single employment decision with regards to Mr. Pope according to policy and according to the safety mandates, not only under federal law, but under state law, the state law of Georgia. You will hear from Mr. Ennis, Mr. Garrick Ennis, who is a rail superintendent who has the supervisory and official authority to make final calls with regards to discipline of rail operators. And he will discuss with you the procedures by which Mr. Pope was either written up or sanctioned for his conduct. At the conclusion of this case, I am confident that you will find there were no adverse employment actions that constituted sex, age, or retaliation against Mr. Pope. Thank you.
Thank you, Ms. Lewis. Mr. Pope, you can call your first witness.
Yes, sir. I would like to call the defendant witness, Mr. Garrett Ennis.
Mr. Ennis, if you would take the stand, please.
Praise be and raise your right hand. You swear affirm that testimony you will give with the truth and whole truth and nothing but the truth, so help you God. Yes. You don't even have a seat. Can you spell your name for the record?
Garrick A. Ennis, Garickennis.
May I proceed?
Yes, sir.
Yes, sir. All right. Mr. Ennis, are you gainfully employed at this time? If so, what's the name of your current employer?
MARTA.
How long have you been employed by MARTA?
Since August 27, 2012.
Mr. Ennis, can you speak up a little bit, please?
Okay.
The chair doesn't have wheels, so you may need to lean in. You can also scooch it, but it's a heavy chair. We don't want people rolling off that little
Yes, sir.
dais.
And that would be August 27, 2012.
Yes, sir. What is your current position title?
Zone Superintendent, Rail Services.
Can you speak up? Say it again.
Zone Superintendent, Rail Services.
Yes, sir. And how long have you been a rail zone superintendent?
I think I was promoted to that position in 2021.
You said about 4 years.
Yes, sir.
What was your previous position prior to being promoted to rail zone superintendent?
Rail superintendent.
Prior to being a rail superintendent, what was your title?
Rail supervisor, tower supervisor.
Prior to being a tower supervisor, what was your position?
Rail operator.
Does that mean you drove trains?
Yes, sir.
Yeah.
Came
for
through
the-
the ranks.
Yes, for the record, I drive trains. Mr. Enos, during your time as a rail superintendent, rail supervisor, have you ever sat in on I'm trying to get my words together. Have you ever sat in on a employment when an employee is, giving an interview for a job?
Yes.
Could you name some of the criteria that employee must have to be promoted?
For one, you have to have the qualifications. And in reference to that, we look at your attendance records, occurrence records, and discipline.
Yes, sir. Is there a certain amount of occurrences an employee has to have before they're not considered for a position?
What do you mean by occurrences?
Occurrences is like when you call off.
Like you miss a day of work?
Yes,
Okay.
yes, occurrence. So, back to my question. Is there a certain number of occurrences that the employee can have before they're not considered the opportunity to be promoted for a job?
Okay, so to be promoted, you first have to apply for the job.
Yes, sir.
And it depends on the job you apply for, 3 occurrences. And it has a scale that they go through and eliminate or recommend the next person to move to the next level.
Okay, for the record, you said 3 occurrences?
3 occurrences.
Yes, sir. No further questions from the defendant.
Okay. Ms. Lewis, do you have any questions for Mr. Ennis at this time?
No, as long as I can call him in my case in chief.
You sure can.
Okay. No
All right,
question.
Mr. Ennis, thank you. You are free to step down. Mr. Pope, who's your next witness?
My next witness is Ronnie Gresham.
Okay.
I'd like to call Mr. Gresham.
Okay, Deputy Gordon, do you mind getting Mr. Gresham? Thank you. Good morning, Mr. Gresham. If you come on up, we've got a chair right here for you. Thank you.
First, if you raise your right hand. Do you swear affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth, so help God? I do. We're going to have a seat. Can you state and spell your name for the record? For my name? Yes.
You can take a seat first. Why don't you get comfortable, make sure you're near the microphone, and then if you would state your first and last name, spelling both.
Okay, R-N-Y, Gresham, Gresham.
When you're ready, Mr. Pope.
Oh, yes, sir. Good morning, Mr. Gresham. Mr. Gresham, are you currently employed? If so, please state the name of your current employer.
Current employee, I'm retired.
Mr. Gresham, what company did you retire from?
MARTA,
When did you retire, Mr. Gresham?
February the 1st, 2024.
How many years of service did you have with the authority, Mr. Gresham?
39 years.
What was your title at the time of your retirement, Mr. Gresham?
Rail operator.
How long was you a rail operator, Mr. Gresham?
33 years.
33 years. Mr. Gresham, could you, oh, no, that's the wrong question. When employees want positions and they apply for the positions at MARTA, would you agree or disagree? MARTA management based the promotion off of their attendance.
Do they base it on attendance? You know what? They don't.
I tell you what, let me ask you again, please.
Okay.
When employees apply for positions at MARTA, would you agree or disagree that MARTA management base the employees, their attendance, before they're able to proceed in promotion?
No, they don't. They do not.
Would you agree or disagree that attendance at MARTA plays a important role in moving up?
It used to, but not anymore.
When did it change?
It changed when they started bringing people from off the street and people from states and stuff. That's what changed. Mm-hmm.
But when was that? You were there for a long time. Was that in the 80s, the 90s?
It really started when Simon Eddy, whatever year that was, I think it was in the early 2000 when Simon Eddy started changing a lot of stuff. He was the CEO at the time.
Okay.
Mm-hmm.
Wait, I got one more question. Mr. Gresham, if an employee has a accumulator of occurrences on their record, meaning a lot of occurrences, would that affect the employee from being promoted?
Negative. It would not. You know, they'll accept anybody, to tell you the truth, regardless of how their records are.
No further questions, Your Honor.
Okay. Ms. Lewis, do you have any questions for Mr. Gresham? All right. Mr. Pope, can Mr. Gresham be excused?
Yes, he can.
Mr. Gresham, thank you so much for being here. You are free to go. Appreciate it. You good? Okay. Mr. Pope, next witness?
No witness. I'd like to enter my exhibits into evidence.
Okay.
Yes.
When you say exhibits, you'll need to, I need to see them. More importantly, Ms. Lewis needs to know which exhibits you're talking about.
Exhibit 50.
Just, that's one, just 50?
Yes.
Okay. Do you have exhibit 50, Ms. Lewis? Okay. If you could share it with Ms. Lewis.
Okay. Yes. I can also
I don't have that exhibit.
Let me take a look. Is it, I have a copy of the exhibit list. Is it the same 50?
yes, sir. I can come show you as well if you need to.
It's okay. It is referred to as a conference record.
It is exhibit 50 is a labor agreement, MARTA and Amalgamated Transit Union 732.
Okay, so that's a different 5. Do you have a different witness list now? You submitted a witness list. You filed one with the clerk, and it's got a 50, and that's listed as some kind of conference record. I don't know what that is, but that's not that thing.
No, sir. I can.
It's a different one?
Oh, no, sir. This is exhibit 50.
Okay, you can put it down. Don't publish it yet. Ms. Lewis, is exhibit 50 anything that either you already had or was provided in discovery?
It was not provided by Mr. Pope in discovery.
Okay,
It is a very close-up picture of an excerpt from the transit union agreement.
okay. Is the transit union agreement something you're familiar with?
Not that portion, Your Honor.
Okay,
I don't know, it doesn't have a page number or any type of citation to where I can reference it.
okay. Mr. Pope, do you have other exhibits that you want to admit?
Yes, but the page number for that exhibit that I'm referring to, I have the MARTA booklet, and that page is in this book right here.
Oh, that's where you got it, was from the book you're holding?
Yes, sir, this is, up to date, 2025 version. This, what I'm trying to get, into exhibit and evidence is in this book right here.
Okay. Are there other exhibits that you are, wanting to admit right now?
Well, after I admit this, yes.
Okay, so I'm just map out for me where you're going, because we may take our morning break so that we can talk about this outside the presence of the jury.
Okay.
I can't rule on 5-0 right now. I think we need to talk about it some, but if there are others, then Ms. Lewis will know they're coming. We maybe can talk about them all together. But just tell me what you're going to admit some exhibits. Do you have other witnesses?
No, sir.
Are you going to testify?
Yes,
Okay, so you do have another witness. You'll be testifying.
yes.
Okay. You want to get these exhibits admitted before you testify?
Yes.
Okay. Then, ladies and gentlemen, we're going to take our morning break a little earlier than I thought we would, but I'm going to spend some time with the parties talking about these exhibits. And it sounds like when you come back in, Mr. Pope will be testifying, and there may be some exhibits that come in. Don't talk about the case while you are, you know what? I forgot to ask you all if you had any questions for Ennis and Gresham after I promised that would happen. My bad, it was sudden. So we'll see how that plays out. I promise if Mr. Pope testifies, I'll ask you guys that. But anyway, during the break, don't talk about the case. Anything in the refrigerator and in that white basket is for you all. You can bring water out here unless you have to have food because of health reasons. Don't bring food out here, but you can bring water out here. We'll get you back out here as soon as we work through what we need to. Thank you.
All rise for the jury.
Any chance Mr. Gresham, is Mr. Gresham sticking around, or do you think he got out of here?
Oh, he's probably sticking around.
See if he's out there. If he is, after the break, we're going to get him back on the stand because the juror had a question for Mr. Gresham. So here's what I need you to do, Mr. Pope. If there are exhibits that you want to admit, I need you to identify them now. He's still here? Can you ask him to stick around? Thanks. It'll only be like 10 minutes, but he does need to stay. If you'd make a stack of those exhibits, so Ms. Lewis knows what they are, and then we can talk about how they might be admitted. So that way we don't have to send the jury out each time. And I guess you should be thinking about the ones you want in, 'cause you're the next witness for your side. Is that correct?
Yes.
Okay.
Yeah, she want to question me about the evidence, so I guess if that's what it's for, me being a witness, I go up there and talk about this.
So if there's any more testimony you want the jurors to hear, it sounds like it will come from you because you called Mr. Ennis, you called Mr. Gresham. And so if you want to testify about what you experienced,
Oh, yeah.
you have to take the stand.
Yes,
You'll be
sir.
sworn in, and then No one's going to be asking you questions initially. You'll be basically narrating. My name is Christopher Pope. I work at MARTA, whatever it is you want to say, but you're just talking with the jury. If there are exhibits that you want to use while you're testifying, those need to be admitted.
Okay.
But you need to make a stack of the ones that you're going to try to admit, so Ms. Lewis can look at them and let me know if she has any objections to their admission.
Yes, sir.
Okay? So we're going to take maybe 5 minutes while you make that stack. When we come back, we'll talk about them. Okay?
Yes, sir.
Thank you.
Thank you.
Oh, and to repeat, actually what we'll do first when we bring the jurors back is get Mr. Gresham back on the stand so that I can ask, let me tell you what their question was. Was Mr. Gresham ever a supervisor or only a rail operator? I think that's a legitimate question. I'll ask it, he'll answer. And if either of you has follow-up, you can ask Mr. Gresham about that, okay? But we'll be on break for 5 minutes. I'll come back, we'll go over those exhibits. Okay, let's get back on the record, please. Mr. Pope, did you compile the set of exhibits you're hoping to admit when you testify?
Yes,
Okay, and did you share that with Ms. Lewis?
yes.
Okay, Ms. Lewis, did you have a chance to look over those exhibits? Okay, any of them familiar?
Some of them, yes.
Okay, how do you want to work through this? Do you have any objection to any of those exhibits? Okay, let's start talking about them. Are they numbered?
Yes,
Okay, if you could give that stack back to Ms. Lewis so she could let me know which ones she has concerns about and what the concerns are. How many exhibits is it?
I can count, Your Honor.
Well, how about this? If there are ones you don't have an objection to, let's just
Those out.
give me those numbers first.
Okay. Well, they're numbered and they're lettered.
Are you going to use the numbers or the letters?
the numbers and the letters. Both
Both?
yeah, both.
Okay, all right. What's the exhibit designation?
Exhibit A.
A? All right, there's no objection to
No
A.
objection to A.
All right, A is okay.
Exhibit B.
B? Okay, we're on a roll here.
Exhibit S10.
S10, no objection.
Exhibit 36.
36,
It's the second page to 36, but it's labeled 36A.
so 36A, no objection.
Right, they're the same document, just one, page 1 and 2.
Well, why don't you, it's just a two-page document?
It is, but they're both labeled with exhibit numbers.
Okay, can we just staple it and it's exhibit 36? You okay with that, Mr. Pope?
Yes, sir.
Okay, I got a stapler that Deputy Gordon will give you. So 36 is okay.
36B.
36B,
Yes, sir.
okay.
Thank you.
Thanks.
36C, no objection. Man, I need the stapler again. It's the same thing, sorry.
It's all right. It's good for him to get steps. Why don't you hold on to that till we're done with this process?
I think there's a 2.8, S28. Same, it's gonna staple. Second. And 1Z6.
One. Can you show that to Mr. Pope? What are you calling that?
Exhibit 1Z6.
One, okay, 1Z, the letter, 6, all right? 1Z6. So the ones you described, A, B, S10, 36,
One second. A, B, okay.
A, B,
Mm-hmm,
S10,
mm-hmm.
36,
30, it says 36. Oh, yes, okay, sorry, yes.
36B,
Mm-hmm.
36C,
Mhm.
S28,
Mhm.
and 1Z6.
Those are the ones I have no objection to.
Okay, can I treat them as admitted now so Mr. Pope can go ahead and use them during his testimony?
Sure, Your Honor.
All right, Mr. Pope, those exhibits are admitted. You don't need to, I mean, you can talk about them, et cetera, but you won't need to say, Judge, I tender X. Those are in. If you want to share them on the screen when you're testifying, you can do that, but there's some with some concerns. And what are those?
Okay,
I need the numbers.
this is exhibit 1Z4. I'm not sure exactly where this is from, Your Honor. I'm not familiar with this document at all.
You're talking about 1Z4?
1Z4, or I'm sorry. Is this I or one?
1Z4.
1Z4.
Okay.
Looks like,
So let's not talk about what it is yet. I just want the universe of
Number-
not okays. So 1Z4, does that need to be stapled because it's a bunch of pages?
yeah,
Okay, let's do that.
S11 is next. Exhibit D,
So 1Z4 and D?
S11.
Oh,
is-
S11, I missed that. Okay, S11, D as in Delta.
That's correct. Exhibit D is in Delta.
Okay,
Exhibit C is in cat.
okay.
And exhibit 50,
50?
50.
All right, so there are 5 exhibits with which you have concerns. All right. And is your concern that you've not seen them before or they weren't disclosed?
But, as well as authentication.
Okay. Mr. Pope, why don't you come on up, and let me know if you disclosed, and if so, when any of those 5, because I don't need to worry about authentication if you were not ever disclosed, sort of like the medical records.
Relevant, John.
Okay, so 1, you may never have received them. 2, how does he authenticate? And then 3, how are they relevant? Okay. We'll get to it. If it's not something Mr. Pope produced, then that ends the discussion. So,
Exhibit D was produced.
oh, D was produced.
My objection to that is relevant.
Okay, let's start with D. Tell me what D is, Mr. Pope, and how it's relevant to your case.
D is relevant to my case.
First, what is it?
It's a grievance.
A grievance.
Yeah, grievance
A
response.
Grievance response?
Yeah, I filed a grievance.
And this is MARTA's response to your grievance?
This is MARTA after they've done their investigation. This
Okay.
is their response.
And is this a grievance that is in the complaint?
This
Because
is the grievance that is in the complaint.
which one?
These, let me see, hold on a second.
The date for this grievance is December 7th, 2023.
Okay, I thought, okay, let me look. Now that I've got your complaint in here. So your complaint, where's the December 7th, 2023? Or where in the complaint do you talk about what the grievance is about?
Number 8 is September 23.
When you were suspended
Yeah,
for
that's-
3 days?
Yes.
And
So-
this grievance relates to that?
Yes, you file a grievance and you wait on the investigation and you.
Okay. Ms. Lewis, do you agree that D relates to the September 23 suspension?
One second. I'm sorry that I'm hesitating, I was only provided 1 page of the grievance, so I can't.
D is only a 1-page exhibit?
It's 3 copies of one of the first, I think of the first page of the grievance.
Okay,
Which I think lacks the substantive nature of, what it was about, but he does state there were absences from August of 2023 that he's contesting with regards to what I have.
okay.
Um,
It relates to an attendance form, et cetera. Any reason why D is just 1 page of MARTA's response?
Sir, I have 2 pages. If you don't mind, can I ask her what date she's She's reading it from her computer that she received it.
She's not, she's holding it in her hand.
Tender. It's just the first page of the agreement.
Yes, right here.
But he's got a second page attached. I just want to find out if the grievance is related to paragraph 8. If it is, you can use it. Can you give her, please, the D?
Oh, no problem, sir.
Your Honor, I don't think that this is related. The conclusion of this grievance removed 4 occurrences off of his record, all 8/1, 8/12, 8/21, and 8/22. I don't think that those are the basis of paragraph 8. This is September 2023 suspension. That had to do with,
A refusal to sign an attendance form.
so
How is paragraph 8, Mr. Pope, related to the grievance?
Paragraph 8 is an incident that I was suspended.
Yep.
Same as that grievance. I was suspended for 3 days for failure to sign
An attendance form.
inaccurate attendance form,
Okay.
which is that grievance. I filed a grievance on the issue.
Oh, meaning that the attendance form was inaccurate?
I filed a grievance on the whole scenario, the 2023 coming into the office, getting suspended for no reason. I mean, for failure to sign attendance.
Okay.
That was inaccurate. So I filed a grievance on that issue.
Okay.
It takes 2 or 3 weeks for the grievance month for the grievance to investigate.
And what you're going to testify to is that D is MARTA's response to your grievance.
Yeah, the response to the unjust discipline that they did on 2023.
Okay.
that's not what this is. He grieved several FMLA related occurrences that were improper. It had nothing to do with you arriving to work and refusing to sign your tardy slip late. This is with regards to disputing occurrences related to FMLA.
Objection, Your Honor.
So you don't need to object in this
Okay.
context. Just let her finish and then I'll hear from you.
Okay.
Dates that they were gave have nothing to do with what's alleged in the amended complaint. And I think that this would confuse, as it's confusing us, it would confuse the jury and conflate issues that don't need to be conflated. What's alleged is that he was unjustly suspended for refusing to sign his attendance record on September 21, 2023. Now, these are August FMLA dates that were forgiven.
Right, but what I'm hearing Mr. Pope say is they're all connected. It was the attendance form showed incorrectly in his mind that he missed days. And so he grieved that, and MARTA ultimately said, oh yeah, look at that. Those were valid FMLA days. They shouldn't have shown up as tardies or missed days. Is that a fair summary, Mr. Pope?
Yes, sir.
Okay, I'm not saying that's actually what happened, but that's his take on it. And so I'm gonna allow D in. I don't want us to take up a whole lot more time. D is something that you did produce, it sounds like. But these others, let's start with C. Let's stick with the alphabet. What is C?
C is the administrative hold that they, I'm gonna show it to you. Administrative hold that they put me on it.
It's okay to show me, you can't show the jury. It's not gonna mean anything to me. Just say what it is.
Oh, okay, this is what the superintendents give, when they want to put you on hold.
Put you on hold like you're on the phone and they make you wait, or hold, what do you mean by hold?
Like, well, suspend you.
Okay.
Yes.
And that's a hold that you received from a supervisor?
Yes.
in connection with which paragraph?
Let me see.
What was your question, Aaron? Sorry.
So Mr. Pope has explained to me that C, Charlie, is basically a suspension notice that he got. He called it a hold. And I'm asking him if it relates to one of the paragraphs in the complaint. And to me, it's relevant. I know you hadn't seen it before, but it's a MARTA document. And so I'm inclined to let that in if it's a hold he received in connection with one of these paragraphs and not something that happened before or after the chronology of his complaint.
Okay, you can exclude this.
Okay, C will stay out. How about 50, 50? What is that?
0. 50 is a labor agreement, Marta's labor agreement.
Oh, this is the excerpt from that book?
Yes,
Okay, let's take a step back. That book, that spiral bound book that Mr. Pope held up when the jury was in here, is that a document with which you're familiar, Ms. Lewis? I don't mean you've read it or you've memorized it, but is that like a MARTA document?
The book?
Yeah.
I don't.
It sounded like it's a,
We do have a labor agreement, Your Honor. This is, says, July 23rd through December 31st, 2025. They typically do print it in a book. I'm not familiar with this particular one.
okay, but that might be something that the union hands out to all the employees, so they've got a copy of the labor agreement. Mr. Ennis is nodding his head, so he's not being thrown a loop by hearing about that. And it sounds like, so let me finish. That Exhibit 50 is an excerpt from that. Is that correct?
Yes.
Where in that, but what page in that book did it come from?
66.
Page 66? Okay. Ms. Lewis, are you or Mr. Ennis able to call up the labor agreement on the screen so you can see, not for me, but are you able, if you wanted to put your hands on the labor agreement, can you do that or is, okay. All right. So it sounds like page, go ahead.
Sir. Let me make sure 66.
Good, you make sure. But it sounds like plaintiff's exhibit 50, 50 is an enlarged version of a page from the labor agreement, which I'm inclined to let in. But you are certainly entitled, Ms. Lewis, to know what page so you can provide greater context either on cross-examination or through Mr. Ennis.
Page 21.
Page 21.
Yes.
Okay, so exhibit 50, is it all of page 21 or part of page 21?
Well, in the book is all, but this particular document I have it's a more like a B. It's letter B. It's talking about seniority.
Okay, can you just hand to Ms. Lewis 50 and page 21, just so she can see, yep, I get it, that's where it came from, because Mr. Ennis is going to be looking that stuff up. All right, Ms. Lewis, is that accurate that plaintiff's exhibit 50 is some part of page 21 from the labor agreement? Okay, I want you to make your record. I'm inclined to let that come in as well. Do you have any objection to that now that you know what it is?
Yes.
What's your objection?
Relevance, and it was not disclosed in discovery. This is my first time seeing that exhibit today.
Okay, I'm going to allow it in since it's part of a labor agreement that MARTA has entered with the union. But your objections are noted. So D and 50 have been added to the okay column. How about 1Z4? What is 1Z4?
1Z4 is a document showing that I applied for ET rail car maintenance journeyman position.
So it's an application you filled out?
Yes, it's, the application I filled out, and it's showing what date that I applied on.
And what was the date you applied?
January 17th, 2024.
January 17th, 2024. All right. That seems to fall outside the timeline of your complaint. Do you agree with that?
Oh, hold on a second. You said it fall off the timeline?
Well, your complaint talks about incidents in 23 and 22. So if you applied for something in 24, that seems like it's outside the scope of your complaint. And remember, we discussed yesterday, you're not going to be permitted to share with the jury. Let me tell you some other things MARTA did that are outside the time frame of your complaint. And so if you applied in January of 24 and were denied that promotion or lateral or whatever it would be, that's not part of your complaint. That may be something new that you bring against MARTA, but that's not this case. Does that make sense?
Yes, it makes sense. But
Okay.
however, number 3 in my complaint speaks about MARTA overlooking me, discrimination, me being passed over for journeyman ET maintenance.
Oh, and is that that's the application?
Yes,
How many times did you apply for journeyman ET radio maintenance?
I applied once.
One, and that's the only time you applied?
Yes,
Oh, okay. I didn't realize there's no date for that paragraph, but that is there. And it is your amended complaint, which did come later on. So then I understand the relevance. Ms. Lewis is saying she's never seen that before. That application you would have submitted to MARTA, or it goes through a outside hiring agency?
oh no, it's submitted to MARTA.
Okay.
Yes,
And when did you provide 1Z4 to Ms. Lewis?
well, okay. I mean, I may be wrong, but outstanding trial management order that was revised 14th January 2025. The exhibits and exhibit list was, it's the deadline was before jury selection, or am I
Is it on your exhibit list?
exhibit list? Yes.
Okay, that one just has numbers. It doesn't have a 1Z. What would it be on your exhibit list? Do you remember? You got 103 things listed.
Okay, exhibit list. I gotta pull it up for you.
Tell me what it's called. I may be able to find it. What's this thing called?
Again, I gotta pull it up, you know.
No, but 1Z4, what is that document called?
It's job application. I forgot what I named it on my exhibit list.
Okay.
So I can.
Yes, it wasn't called application. Let's see. Job. That's not there. Okay. Ms. Lewis, as you were preparing for this case several times and looking through, I think you referred to a document that's sort of like the personnel file for Mr. Pope. Would something like that not have been in there? An
I
app?
don't know where he got that from, that's not in there. There's nothing like a document MARTA would produce in regards to a job application.
Okay.
I'm not sure where he got that.
Where'd that come from, Mr. Pope?
Well, you know, when I apply for the job, I take a picture of the job I applied for, and when they denied the
Does 1Z4 have the denial in there, or
Well-
it's just your application?
well, the 1Z4 has the what I applied for, and 1Z5 is showing you that this particular document is me, individual, as you can, well, you don't see it right. Are you looking at it right now?
No,
I'm sorry.
I don't have it.
I'm sorry, but at the bottom of the document, it shows that, when I was a part-time bus operator, offer being accepted to me. So this document is relevant, and the exhibits that you have already admitted which she looked at and confirmed. This is the document showing that was stating that I was denied for the position.
That's the 1Z6?
Yes, this the one that you guys already admitted.
Well, I'll tell you what, 1Z6 is in, and that'll be proof that you applied because you were denied that position. I'm not going to allow 1Z4 in because it sounds like it wasn't produced. And that gets us to the last one we need to talk about before we bring the jurors back in, and that's S11. What is S11?
Yes, sir. S11 is a part of, again, my amended complaint.
Well, first, what is S11?
S11 is a email from the superintendent that's in my amended complaint by the name of Kenneth Jackson. That will be number 1 second. This.
I see. It's paragraph 9.
Yes,
top of
sir.
Page 5.
Yes, sir.
So it's an email from Mr. Jackson. Is it the one that he sent to 49 employees?
Yes, yes, employees, may I add, management employees, not.
But it's specifically the email that you reference in paragraph 9.
Yes, sir.
Okay, seems relevant. Have you seen it before today, Ms. Lewis? Okay. Is the contents of the email something particularly problematic that you can't prepare for, Ms. Lewis? I appreciate you haven't seen it before. I just don't know what it says other than that you would have known, assuming it's consistent with what's in the complaint, what was in that email.
Okay, I get what you're saying. The contents,
How long is the email?
it's less than a paragraph. It merely states that he's not to be allowed on the property during the suspension.
Okay.
It's sent to, I can't tell who it's sent to. My concern is it wasn't provided and it's not printed in a format where I can easily authenticate it or say that it was not altered or tampered or, mismanaged in some way. It looks like it's a picture of, I don't know, something.
Okay, but I think that'll go to the weight of that evidence. I'm going to allow S11 in. And so let me recap on the record, and then when the jurors are in here, I'll let them know. I find that A, B, D, S10, S11, S28, 36, 36B, 36C, 50, and 1Z6 can all be admitted. And Mr. Pope can tender them and publish them during his testimony. 1Z4, S11, and C, 1Z4 and C are not admitted. 1Z4 and C, do not try to tender them, don't put them up on the screen, but all the others, you should have a pile of okay, and then the others, put them somewhere else.
Yes, sir.
Okay. And Ms. Lewis, those are admitted over your objections. Some of them were relevance, sufficient foundation, or late production, which isn't so much an evidentiary objection as it is the rules of discovery. So you preserved that for those records. Okay?
My concern is there are some I don't have copies of. For example, Exhibit D, I have the first page, I don't have the second. Is there a way I can get copies of the ones I don't have?
At some point, yes. I don't want to extend this break any longer. And so if you can, Mr. Pope, if you would please give Ms. Lewis that stack of exhibits that are coming in. Ms. Lewis, if you'll go through those and figure out which ones you need copies of, I'll get copies made. So you've got a set. And then the originals will be what go back with the jury, if any of those go back with the jury, but they'll certainly be made part of the record. Okay? So if you could right now, Mr. Pope, give Ms. Lewis that stack of the exhibits I rattled off that are in, and she's going to make a note as to which ones she needs copies of.
Yes, sir.
All right. And if you could bring Mr. Gresham back in, we're going to start with him on the stand. Hey, Mr. Gresham, thank you for sticking around. I skipped one part of your testimony, so if you'll take the stand again, we're going to bring the jurors in. I think probably one or two more questions.
I was under the impression that you wanted me to leave, period.
So I didn't want you to do anything other than you were excused. So if you wanted to go, you were free to go. But I was mistaken, because what I said was truly, if you want to go home, you should go home. But then someone pointed out that I missed something. And so I'm glad you stuck around. But when we're done this time, you do not need to stay in the building any longer, but you're welcome to. You can even stay in court if you want. If you want to watch more of the trial, you're free to do that. You do whatever you're most comfortable with. Okay? Mr. Pope, have you given Ms. Lewis those exhibits?
Yes, I'm doing about 30 seconds. I'm ready.
Pardon me?
About 30 seconds. I'm just writing them down.
Okay. All right, Mr. Pope, are you ready for the jury to come back in?
Yes, sir.
You'll get those back. She's just going to note which ones she needs copies of. Ms. Lewis, are you ready for the jury?
Yes, sir.
All right, let's bring the jurors in, please. Did you take a break when we first, Ms. New, did you take a break when we first took the break?
Yes, I would.
Good, okay.
All right, for the jurors. Okay.
All right, everyone else can take a seat. Ladies and gentlemen, thank you for your patience. 3 quick things. 1, there are no assigned seats, so I encourage you to rotate around. Literally, you'll get a different perspective on what's going on in court, unless one of your colleagues needs the end because he or she needs to stand up periodically. So don't grab a seat and say it's always yours. 2, come on in and sit down. You don't need to stand. We stand for you. You're welcome when you do get in to take a seat. 3, I neglected to inquire whether you all had questions of either of the first 2 witnesses. they went a little more quickly than I had expected, and I just hadn't gotten into my groove yet. So I've called Mr. Gresham back to the stand. He remains under oath, and we're going to pick up with his testimony. Mr. Gresham, I have a question for you. But before we do that, let me adjust one thing. Okay, Mr. Gresham, were you ever a supervisor for MARTA?
Negative.
Okay, you were always a rail operator?
Rail operator, yard operator. That's it.
Okay, is one of those positions more senior than the other or get paid more? A rail operator versus a yard operator?
Same pay.
Same pay? Rail operator means you drive a train.
Rail operator means you drive a train. And in other words, rail operator has, if he's on the extra board, he has, if a yard job is open, he has to do that work.
Okay, what does a yard operator do?
Yard operator is putting trains together.
Okay,
Let's see what else.
getting the train ready to go, and then the rail operator hops in and goes off to Sandy Springs
Either to the airport.
or airport or wherever.
Yeah.
Indian
that's
Creek.
the duty of a yard operator. He's always putting the cars into the shop and taking cars out of the shop because mechanics are not allowed to operate the train.
Okay,
We have to operate it to see if the train is functional
okay,
when they're working on it.
got it. And your two jobs you had at MARTA were rail operator and yard operator.
And my younger years, it was a bus operator,
A bus operator, okay, but not a supervisor.
never a supervisor,
Okay,
because they wouldn't allow me to be one.
okay. Mr. Pope, do you have any questions for Mr. Gresham based on the exchange he and I just had?
Oh, no, sir.
Okay, Ms. Lewis? All right, Mr. Gresham, now you're really done. Thank you for coming back. I appreciate it.
And you said,
You're welcome to stay here in court. You're welcome to leave the courthouse.
okay.
Okay?
All right.
Thank you so much. Oh, because I hadn't asked, I mean, that some people, take a seat, Mr. Gresham. Hold on one sec. Mr. Gresham, come right back. I'm sorry. I thought all the questions for Mr. Gresham had been written down, but I didn't ask. Some folks had done that. Does anyone else have questions for Mr. Gresham? It's not usually this chaotic. I manage it better. Hold on one second. Okay. Mr. Gresham, couple more questions. Can you tell the jurors how you know Mr. Pope?
I know Mr. Pope as a coworker. Only as a coworker.
Were you ever involved in making any decisions as to whether Mr. Pope should get a promotion? No?
Nope.
Okay. And it sounds like because you were never a supervisor, you would never have been Mr. Pope's supervisor? No?
Nope.
Okay. All right. Any other juror questions for Mr. Gresham? Mr. Pope, any questions for Mr. Gresham based on my additional exchange with Mr. Gresham?
Oh, no, sir.
Okay. Ms. Lewis? All right. So you can take, you're free to leave the stand. I promise I won't drag you back up here again, okay? Thank you, sir. Appreciate your time. All right, Mr. Pope, who is your next witness?
Myself.
Okay. Ladies and gentlemen, during your break, I ruled that the following exhibits have been admitted. And if Mr. Pope or Ms. Lewis want to publish them, make them viewable by you all, they are free to do that. A, and these are plaintiff's exhibits. So Mr. Pope's exhibits, A, B, D as in Delta, 36, 36B, 36C, 50, S10, S11, S28, and 1Z6. Those are all in evidence, and if it's appropriate for them to go back during your deliberations, you'll have those documents. And Mr. Pope, you're free to publish them during your testimony if that's what you want to do. But what I need you to do is come on up here to be sworn in by Deputy Gordon. You may want to bring your laptop if you're going to publish exhibits while you're testifying.
Yes, sir.
But come on up, bring your laptop or the exhibits, however you want to do that. Does he have them back?
I have the stack of the ones I needed copies of.
Okay, if you could send an email to me, listing the ones you need copies of, the numbers, yep. And then during the break, we'll make sure you get copies.
One quick second.
Thanks.
All right, Mr. Pope, come on up with whatever you need while you're testifying. All right, and put that down, but stay standing so you can be sworn in by Deputy Gordon.
Yes, sir. Raise your hand. You swear affirm that the testimony you'll give will be the truth, whole truth, nothing but the truth, so help you God. Yes, I do. You go ahead and see. If you say this, spell your name for the record.
Christopher Pope. CHRISTOPHER. His name POPE.
When you're ready, we talked about this is going to be more of a narrative. No one's asking you questions on direct.
Yes, sir.
But when you're done, you'll be subject to cross-examination from Ms. Lewis if she has any questions for you.
Okay, yes, sir. She kind of switched my paperwork up, so I had it
Okay.
in order.
You put it in whatever order you want.
All right, thank you.
Please, though, for the record, make sure if you're talking about an exhibit, you let us know which one you're talking about.
Yes, sir. Will do. May I, if you don't mind, may I add to the record? Ms. Lewis made a statement.
So you're testifying now, I mean, you're adding to the record because you're testifying. This is your opportunity. It's as if you were asking yourself questions about your case, how you're connected to it, what your allegations are. It's time to get into that if that's what you're going to do.
At this time, I will be entering into evidence exhibit 50.
Okay, it's in evidence. What you're going to do now is publish Exhibit 50.
Okay, this is a labor agreement, MARTA, Obligated Transit Union 732. This is the page from our union contract book. And I am showing a paragraph that states about our seniority as far as being promoted. And it reads, may I read?
Do you have it's in evidence so you can read it. Do you have a digital copy or only the hard copy?
Yes, sir.
Is it possible to pull it up and then share?
Pardon me?
Is it possible we can have Mr. Pope pull it up and then share his screen?
Yeah, I think next time we'll do it that way. So once you get it on your screen, then share. So why don't you, here, I'll help out.
Yes, sir.
All right. I can't tell what's on the screen now. There, it's gone. So you find your document, and when you found it, then you screen share. Tell you what, Mr. Pope, why don't you read it to the jury? That's an exhibit they'll have during their deliberations. But I need you to be able to find stuff a little more quickly if we're going to be publishing it.
Yes, sir.
And make sure you read slowly so the court reporter can take it down.
Okay. To the jury, I apologize for the wait. It's a letter B application. CRE shall pay the accrual of vacation and sick leave, pension rights, job opportunity, and job security as set forth in the provision of this collective bargaining agreement. CRE shall not apply to the continuation of health insurance benefits. Such benefits shall be available only to active employees. At this time, I want to publish document, conference record, MARTA conference record, document
What's the exhibit number or letter?
Exhibit A.
Okay.
Exhibit A.
Is that something you can find on your screen quickly or not?
Yes.
Okay, then why don't you publish it?
As you can see on the screen, it's a conference record, and that conference record is pertaining to a suspension that I was placed on for refusal to sign a conference letter for 4 occurrences. I refused to sign that conference sheet stating 4 occurrences because if I had signed the sheet, then I would have been able to be promoted to journeyman. I refused to sign it because it's an inaccurate number of occurrences. At the time, I had 0 occurrences.
I want to make sure I followed what you said. You said if you signed it, you would be eligible for a promotion or you would not?
No, if I signed it, they would not promote me. Like, you got to have like Mr. Ennis said earlier on the record, the 3 occurrences, it's hard when they won't promote you, you got 3 occurrences.
Okay.
And this is just a conference sheet showing that I refuse to sign it. And this is why I refuse to sign it. I would like to On that, issue, I filed a grievance. When, we have an incident or, something at MARTA, you file a grievance and they, MARTA does an investigation and they give you a response to what you file. And I'm pulling the, response up.
And what exhibit is that?
This is exhibit B.
D or B?
B,
D as in Delta.
yes.
Okay.
And in that exhibit B, can I read the whole document or?
So the documents in evidence, I'm gonna ask you not to read the whole thing, just summarize it for the jurors, but they'll have it to review during their deliberations.
Okay, well, the document B just, giving a, determination. And the determination was that Mr. Pope, which is me, didn't have no, well, she, the manager and that was, who did the investigation, she took all the four occurrences off of my record. She said that it was, inaccurately placed on my record. So, in other words, I have no occurrences, at all. So,
So what are you publishing now?
publishing exhibit 36.
Okay. Yeah, why don't you take that, why don't you stop sharing? So we're not scrolling through documents that are not part of the record.
There you go. Again, this is exhibit 36. This is a rail transportation preliminary incident report. And it,
Can you share your screen now?
yes. This document is again, it's a document made by a supervisor by the name of Truton Kirkland, and which he made several unjust write-ups about me, and he issued it to me, and it which led me to get suspended. And hold on a second. Let me put this right here. Yeah. And this is another document of right now it's superintendent's write-ups that I received. Let me take this screen. And because of this incident that happened through 2023, which Trenton Kirkland wrote me up. Fast forward to 4/5/2023, which is Exhibit 36B. Thirty-six B was a suspension from Superintendent Kenneth Jackson. And it's another conference record of a suspension. And the reasoning for the suspension is failure to acknowledge receipt of transmission. I was suspended for 3 days. If I may, can I explain to you about moderator in trains? Our radios is not 100% accurate. You know, it's about 50%. You know, there's blank spots from the airport to North Springs or wherever you're operating in the east-west. There's blank spots up and down the railroad that you can. I'm hearing the radio. I'm hearing the radio. So this is a suspension. Also, during that suspension, after he suspended me, this individual sent an email to like 50 people in management and advised them to show up on the property to lock me up, have my police to lock me up, which is not MARTA's policy. You know, MARTA is a public transportation. At the time, during that time, I was utilizing MARTA during that time. I want to say about utilizing MARTA for, but it was not MARTA. So, but this is was not fair. It's not MARTA rules to and it kind of put a bad image on me to management. So I'm trying to pull up that email, if I may.
Is that not what you just had? If you'll scroll up a little bit, you had S11 on the screen.
Yes.
Okay.
It says, if I may read it, Christopher Pope has been placed on a 3-day suspension starting on 4/6/2023 and ending on 14/2023. Please do not schedule Mr. Pope for any work during the dates mentioned. Mr. Pope is to not be on the property during his suspension. If Mr. Pope does show up, please have him escorted off the property by calling the MARTA police. And we sent that to like 50 people in management, all management, no employees, but no labor employees, all management. And that I'm here with my opportunity of moving up, being promoted.
All right, don't scroll through other stuff.
I'm
If
sorry,
you
sir.
want to share another exhibit, you should unshare unless it's the very next one.
Okay. This time I'll be entering publishing exhibit 1Z6. Your Honor, I think this exhibit was the one I was referring to earlier when I said that it don't show clear on my screen.
Okay. If you want to publish it to the jury by handing it to a juror and they can pass it around, it's your decision.
Yes, sir. I can do that. This particular document was the document that denied me promotion for journeyman ET maintenance. I would like to show you guys if that's not a problem.
All right, you can take a seat and keep going while they circulate that.
Yes. That'll be all, sir.
Pardon me?
That'll be all.
Oh, that's the end of your testimony?
Yes.
Okay. Ms. Lewis, do you have questions for Mr. Pope?
Yes, Your Honor. Mr. Pope,
Yes.
do you understand what an EEOC complaint is or charge?
Well, I filed an EEOC complaint.
So you have filed EEOC complaints against MARTA, correct?
Yes.
None of those complaints dealt with you being passed over for the journeyman ET radio maintenance position, isn't that correct?
I may have to. I did 4 EEOC complaints, so offhand, I'm not sure.
Do you remember me taking your deposition testimony?
Deposition.
Yes, on November 6, 2024.
Yes, I do.
Do you remember me asking you whether or not you had ever filed an Equal Employment Opportunity Commission charge for being passed over as a journeyman ET radio maintenance personnel? And do you recall saying no, that you had not?
Can I repeat the question again?
Sure. Do you recall on November 6, 2024, you telling me that you had never filed an EEOC complaint for allegations regarding being passed over for a journeyman ET radio maintenance position?
I will tell you that in my amendment complaint, I did an amendment complaint, and it's in there.
Correct. And you also stated that you had never filed an EEOC complaint for that particular charge, correct?
Yes.
Likewise, you have never filed a charge for violation of your civil rights under the Occupational Safety and Health Administration Act, correct?
Like I said, I filed an amendment complaint.
And so I'm only speaking what you have filed with the EEOC at this time.
Yes, I understand.
And isn't it correct that that particular claim was never filed with the EEOC?
As I remember, when you asked that question, I told you that the judge gave me the opportunity to go admit my complaint, and that's what I did.
Sir, do you realize that the judge and the EEOC are two separate entities?
Yes, I do.
Okay, so I'm only speaking to what you have filed with the Equal Employment Opportunities Commission at this time. With regards to your claim that you were denied a relief break on October 5th, excuse me, one second. With regards to your allegations that you were discriminated against based on age, sex, when you complained about a hostile work environment. Isn't it correct that that particular claim was a EEOC complaint ending in 05796 that related to an EEOC charge ending in 05796?
05796.
Yes, sir.
Yes, if you don't mind, can I get my document? 05796. Sir.
You need his exhibits?
If there's something that will help refresh your recollection, you're welcome to get that.
Yes, yes.
Okay. Just a quick recap. We're talking about the claims that you have filed in your complaint. We've already established with regards to your first claim, you had over agreement, there was no EEOC complaint filed with regards to that. We're on to your next complaint that that you were discriminated based on sex and age when you were written up for failure to follow instructions in January 2021. That was paragraph 4 of your complaint. And you testified at your deposition that those claims were related to your charge that you filed with the EEOC ending in 05796. That's correct so far, correct, Mr. Pope?
As before, I advise you that I did an amendment complaint.
Sir, the paragraph 4 of your amended complaint with regards to you being written up for failure to follow instructions in January 2021 relate to a charge that you filed with the EEOC ending in 05796. That's correct?
Ma'am, again, that's before, and I filed my amendment complaint.
But so we're clear, I don't want us to go around in circles. The amended complaint, you're referring to the amended complaint here in Superior Court, not an amended complaint with EEOC, correct?
No, it's amendment complaint with Fourth Superior Court.
Right. So there's the litigation going on here. There's whatever you have going on with EEOC. Your amended complaint here, that's not EEOC, correct?
No.
Okay.
Not sure if he answered the question, Your Honor.
You can, no, you should ask again. I just want us to get out of this circle of, well, but I filed an amended complaint. The amended complaint, I just wanted to be clear,
Okay.
you're referring to is the amended complaint in this case with this jury, not EEOC? And he said yes.
Thank you. I want to ask it again, sir. Paragraph 4 of your amended complaint relates to an EEOC charge you filed ending in 05796, correct?
Yes, number 4.
Yes, thank you. And isn't it correct that the EEOC issued a notice of right to sue without making any findings against MARTA on July 5th, 2000, or excuse me, on April 5th, 2023?
I was issued a right to sue from the EEOC.
Correct, on April 5th, 2023.
It's April 2023.
And you are more than aware that you only have 90 days after that date to file suit with regards to the claims in that EEOC charge ending in 05796, correct?
I'm aware now. Yes.
The notice of right to sue tells you that, doesn't it?
Yes. Notice the right to sue. Yes.
You filed suit in this matter on September 28th, 2023, correct? I can show you your complaint that will refresh your recollection, Mr. Pope.
Yes.
All right, this is your amended complaint. That should be. But let me just ask you, Mr. Pope, do you recall filing suit back in September of 2023 in this matter that we're here today to discuss?
You can ask me your previous question.
So she gets to ask whatever questions she wants, not, you don't get to go back or forward.
Okay, well,
But you're free, let me finish.
So sorry.
You're free to expand your answer if you want to do that, if
Okay.
you think of something in response to a new question. Why don't you pose the question again?
Do you recall filing suit back on September 28th, 2023 in the action that we're here today for?
No, I don't recall.
Okay, when did you file suit?
In the action that we're talking about,
Yes.
I can very well get that information if I go on my EEOC website right now. I'm wondering if I can get that information for you.
The question is not about EEOC. It's, do you recall when you filed this lawsuit, the one that brings us all together?
No, I don't.
Okay. He doesn't recall the specific day, which is fine. Just her question was, do you remember when you filed this lawsuit?
Yes, I can get that information for you though.
Sure. Do you recall that it was after July 5th, 2023?
In the 05796,
No, sir.
No, this lawsuit. The question is, when did you first bring this lawsuit?
again, I don't recall how I can get that information for you.
I'm stating that it was after July 5th, 2023. Do you agree?
As I just said, counsel, I can get the information, the correct information for you.
You don't know off the top of your head, though.
Not off the top of my head.
Okay, well, I'm going to take judicial notice of the fact that, give me 1 second, I'm pulling it up, the official docket, so we don't go around in circles on this. Your original complaint was filed on September 28th, 2023. September 28th, 2023 is when you filed your first complaint. I know you amended it later on, and we're going forward with the amended complaint. But the first one, September 28th, 2023.
And Mr. Pope, that is more than the 90 days that the EEOC gives you to file suit, correct?
September. Would you repeat?
I
Yes.
can recap, sure.
Okay.
The notice of right to sue was issued on April 5th, 2023. EEOC noticed you for 90 days to file suit, and you didn't file suit until September 28th, 2023. That's more than 2 months after the 90-day deadline of July 5th, 2023, correct?
In that, yes, in that particular 05796, in that particular case, yes.
Okay.
Well, this incident, 2021 incident you're referring to.
Okay, I'm moving on to your next complaint with regards to OSHA. And paragraph 5 of your amended complaint, you allege that you had civil rights under OSHA that were violated when you were denied a relief break on October 5th, 2022. Is that correct?
Yes, in my amended complaint, yes.
And a conference record was drafted with regards to that incident, correct?
I'm not sure,
Excuse me, a preliminary incident report.
but I'm not sure, in my discovery that I sent to you requesting that document, you never, well, I was outside my discovery and I was never, provided that document from you.
You never received a copy of your field file from me?
We're not speaking about field file now. Field file is, a lot of documents, meaning like, since the time I started, MARTA, we're talking about the specific document you're talking about, this October 2022 document that you just asked about.
Mr. Pope, my question is, have you ever received a document called a field file or a personnel file prior to today?
Okay, you asking that question, field file. I requested my field file from my superintendent about 6 months ago, probably 6, 7, 8 months ago.
And did you get it?
Yes, I got got it from hand to hand, not through email or anything like that.
Okay. But whether it was hand to hand or delivered on a truck, you did get a copy of your field file.
Yes, from my superintendent, yes.
Okay.
And also council just emailed me
Thank you.
my field file about 2, 3 days ago, about a week ago.
Okay.
I think that misstates the evidence, but I'll go with that. You were provided a copy of a preliminary incident report with regards to the October 2nd, 2022 denial of a relief break, correct?
Council, go ahead and show me that document.
Sure, if that will refresh your recollection.
Yes, this is a document that I have been requesting. Yes, thank you.
On October 2nd, 2022, you were written up via that, a preliminary incident report was drafted based on your violation of the emergency relief policy. That's correct, Mr. Pope?
Correct, emergency relief policy.
Are you familiar with the emergency relief policy?
No, ma'am, I'm not familiar with the emergency relief policy. However, I'm familiar. Go ahead.
I'm sorry.
Thank you. I'm familiar with when I was a request for emergency relief. What the management have to assist them after they request for emergency relief.
MARTA communicate its policies to rail operators such as yourself.
General order.
Okay,
Yes.
let me show you what I marked as Defendant's Exhibit 1.
Can you mind leaving that over here, please?
Okay, I'll give it back.
Okay.
I need it. This Defendant's Exhibit 1, could you please state to the jury what you recognize this as?
Well, counsel, like I told you yesterday, it's the first time I've ever seen that document.
Okay, I'll read the title for you. It's a new emergency relief policy. And it's General Order 09-07. Have you familiarized yourself with MARTA's General Emergency Relief Policy?
Again, counsel, this is my first time seeing that document. And may I add this right here, if you don't mind, please? We issue general orders in our department. Every operator had to sign and date it. This document does not have my name on it, nor my signature. And that say something, and I believe Mr. Enos, superintendent over there can affirm that. Okay, sorry.
No, was there more you were saying? You're saying, for
Yes.
whatever reason, you've never seen, 09, 07.
Well, she sent me to my email last week.
I don't mean in terms of produced in discovery, but you as a MARTA employee, you've not seen that general order before.
No, so as a body employee, I never seen that document. Then it was 2009. So, like I said, everybody got to sign when they put the general order out.
And your testimony before this jury today is that you have never been aware of MARTA's emergency relief policy as an employee, a rail operator employee.
Today, I'm saying I've never seen a document that you are providing.
My question is whether or not.
I never seen it.
Of a policy regarding how rail operators take emergency relief when they're operating a MARTA train.
Well, there was never a policy in place, which is request for emergency relief. That's not in our contract book. Nor is it in MARTA booklet at human resource. It would be in this right here if it was a.
Objection, Your Honor. It's showing an exhibit that is not.
Well, so leave it flat. You don't have to hold it up, but the testimony is not objectionable. You're saying that if there's something about emergency relief policy, you believe it would be in something you are provided with.
Yes, because we're on a contract, we're a union, and if they want to include new rules or new policies, they have to contact our union first within 5 days. And the union will advise its employees, and they would be in our contract book.
Mr. Pope, have you looked in the union book for the emergency relief policy? And is that something that you've done prior to today?
What union book are you referring to?
The one that you just referred to that has all of MARTA's policies, safety policies.
This book right here, this is the union book I'm referring to right here.
Prior to today, Mr. Pope, have you ever reviewed MARTA's emergency relief policy?
Miss Council.
So no question, you can answer it and then explain.
If she's talking about this book right here,
She's not talking about a book. The question was, have you, Mr. Pope, ever reviewed MARTA's emergency relief policy?
again, as I stated before, emergency relief policy, I've never seen it or reviewed an emergency relief policy.
How did you know of the concept emergency relief? You actually brought it up. How did you learn about emergency relief?
Oh, yes, great, thank you, that's a good question. Emergency relief is when the operator, operating and they get tired or they have to use the restroom or have to get some water or something like that. They just come over there and request for emergency relief.
Okay, I got that. How did you learn that you could do that? How did you learn I can come on the radio and say, this is Unit 17, emergency relief? Was that in a book? Was that a supervisor who taught you about emergency relief?
No, it was not in a book. It's just what everyone was doing, if they needed to get off the train, they needed a break. That's what we just request for emergency relief.
Okay, and you learned that you could do that you could get on the radio and say, I need emergency relief because you saw someone else do it, or you were trained to do that, or you read it on a piece of paper?
No, I didn't do it on a piece of paper. I mean, other operators before me, under me, came before, after me, when they use the restroom and they operate the train, they request for emergency relief. They call it emergency relief. And they go use the restroom.
Right, how did you learn to do that?
Watching other operators.
Okay, there we go.
May I, may I add, may I add something in regards to the,
About emergency relief or something
yes,
different?
the general order emergency relief.
Okay,
Yes.
let's wrap that up.
The general order, you can, well, that's, she can find the general order inside of the matter, I mean, with, SOPs and things like that. She can find, well, general order and the meaning of the general order, and when they're, when it's given to us, she can very well find that herself, you know.
Okay, I think she's more focused on you finding it, but why don't you ask your next question?
Sure, Your Honor. Mr. Pope, with regards to your paragraphs, 3, 6, 7, 8, and 9 of your amended complaint, your deposition testimony was that you never filed any EEOC actions with regards to those, charges. Is your testimony changing with regards to that today?
Could you repeat, please?
Sure. With regards to paragraphs 3, 6, 7, 8, and 9 of your amended complaint, your deposition testimony on November 6, 2024 was that you never filed any EEOC actions with regards to those charges. With regards to those complaints. Is your testimony different today?
So again, I said that, I was able to make my complaint.
Your testimony is not different.
No.
And so I'm clear, and maybe others in the room, when you're talking about amending your complaint, you don't mean amending a complaint with EEOC, you mean amending your complaint that is the lawsuit here in Fulton Superior Court.
Yes.
Okay,
No further questions, Your Honor.
all right. Mr. Pope, if you had an advocate on your behalf, that person would have a chance to do what we call redirect, and you'd be able to provide additional testimony that's responsive to the questions that Ms. Lewis just asked. Do you have anything more you want to share with the jury based on the questions that Ms. Lewis just asked you? I'm not going to forget, I promise this time.
Yes. Also, from my understanding, Ms. Lewis was asking me the deposition and EEOC complaints that I made. And I recall after she asked me about my EEOC complaints, I told her I advised her that I was able to amend my complaint with, not EEOC, but with the courts. So that's about it.
Okay. Any recross, Ms. Lewis?
No, Your Honor.
Okay, any questions from the jurors? If you need a note card, grab a note card, but if you've got any questions for Mr. Pope, now's the time to write them down and get them to Deputy Gordon, please. Thank you, sir. Are there more coming? Okay. All right, Mr. Pope. Are MARTA employees required to review policies as part of their training? Like the policy on emergency relief, things like that. As you're getting trained for your job, whether you're starting or you got a promotion, are you required to review the policies?
Yes, the policies, well, training, okay, you talk about training, meaning like when you first start working at MARTA or training,
Well, let's take both. You first start working at MARTA. Are you required to review MARTA's policies for employee conduct and anything there might be, like a policy manual?
review, they give us a policy. I'm not sure, during training, they don't give us no policy about emergency use in the restroom.
Okay, but let's step back from emergency relief. Are you saying that that spiral bound book is the only thing you're given when you're hired and you're being trained for a job? Is it's that, and there's not also like the vacation policy if you want to put in for leave, or information about retirement benefits, or if there's a 401k, or some jobs have dress codes, and that's a policy, it's not the law.
Yeah.
And so you're given a policy set of documents. It may be a binder, it could be a thumb drive, I don't know. But I'm wondering, the question is, when you are being trained, whether it's day one, forever, your first time at MARTA, or you got a promotion, are you given policies that you are expected to review and know?
Oh, yes, yes, we're given policy.
Okay, but you're saying that the emergency relief policy or whatever it would be wouldn't have been in that collection.
I'm saying it's new. I've been at MARTA 13 years, and I've never seen that document, emergency relief. New emergency relief dated 2009. And I'm saying if that is an official document, then Miss Lewis should have that, the part two of that document that,
Where you
every
sign,
employee has to sign it. There's just, it's a rule. That's not, I'm not saying it was a rule.
okay. You had Exhibit A and D, both of which are in evidence. A, I think, was the write-up that you got, where you were suspended, and then D cleared that up and reversed the suspension. I think you were given back pay or something. The question is, what are the two dates for those things? When did A happen and when did D happen?
A happened 9/21/2022. That's when I went in for in the office.
And then when did D happen? When was it cleared up that you shouldn't have been suspended?
D happened December 7, 2023.
So
That's when I was issued the determination.
a determination?
Yeah. Yes, grievance response determination.
Okay. So,
Wait, I'm sorry, decision on the grievance.
so 2 years later.
No, December 7, 2023.
Okay, and I must have misheard. When did A happen?
9/21/2023.
Oh, 23. Okay, got it. Okay, so 3 months later.
Yes, no, that's exactly 9.
Okay.
September, I don't know.
Got it.
Yes.
Tell the jurors again, please, what you were suspended for in April of 23. And it may be March of 23, as I look at your complaint and I'm reconciling the
Yes.
juror question.
It was, March of 2023, and for the record, allegedly, this is what, the superintendent, well, the super, hold on, let me see.
This should be the Supervisor Kirkland situation.
Yeah, Supervisor Kirkland situation. Again, it was a write-up, and when you get wrote up, you have to into the person who's over the supervisor to call you in for a meeting to stand, I guess, to visit your charges. And on 2022, that's when I had my meeting from 3/27/2023.
Okay.
In other words,
The incident was in March, the actual write-up was in April.
yeah,
We're talking about the same thing.
yes, well,
And what were you written up for? That's the question.
okay, 3/27/2023, the supervisor wrote, failed to follow instruction, failed to acknowledge receipt of transmission, making untrue, dishonest, or misleading reports, failed to remain alert, failed to secure the train doors, and can I speak about this document?
So the question is, what were you suspended for? And you're reading the things that they said you did.
Okay, well, 4/5/2023, that's the meeting for this date right here.
Okay.
For these charges right here.
Okay.
You know, and in 4/5/2023, the superintendent is speaking about the 3/27/2023 incident, and he summed it down to failure to acknowledge receipt of transmission and repeating the transmission when required to. So that's what he wrote me up for.
Okay.
I mean,
And what was the
really-
consequence for allegedly doing those things? Were you suspended or?
Well, you got suspended for 3 days, but consequence, according to the rule, they gave me this is not really the consequence. This is something that he just did, 3 day suspension. I have the rule book with me over there. If
So the rule book is something different from this book you keep picking up?
yeah, this the contract book, rule book.
And would the rule book have something about emergency relief in it?
The rule book will only have pertaining to nursery use restroom. It will have we're not supposed to actually use the restroom like on a train or something. Like we have to request for someone to come relieve us. Basically, just say only that you're not supposed to use the restroom on the train, like actually use the restroom, and you get suspended or termination for that.
Okay. In connection with your 3-day suspension for the radio scenario, you shared an exhibit that was an email that Supervisor Kirkland sent out saying, hey, if Mr. Pope shows up, he needs to be escorted off the property. Do you remember that?
Yes, it's Supervisor Kirkland, Superintendent Kenneth Jackson.
Okay, Jackson. And that was in connection with you being written up by Supervisor Kirkland. Is that correct?
There you go, sir. Yes.
Okay, so Superintendent Jackson sends out that email. Do you know if it was policy for the superintendent to send an email out to other managers when a MARTA employee is suspended to make sure that that MARTA employee doesn't try to report for work?
I don't think that's policy, sir.
Speculation.
If you don't know, you don't know.
No, I don't know, but
So if you don't know, then that's your answer to the question. The question was, is it policy for MARTA to do what Superintendent Jackson did, which is say, look, here's an employee who's suspended for these 3 days. If you see him on MARTA property, you need to call MPD to have him escorted off.
That's not a policy, sir. Thank you for, saying the whole part of the email.
Okay.
In part, by the police.
Okay. Last question. Tell the jurors why you think you were discriminated against on the basis of age. That's one of the things that you brought up, and the jury wants to understand why you think that.
I think that because I know there's a middle name, but but Marta, I had younger people for a position that I applied for, outside and well, internal and external employees, and I feel like I was extremely and retaliated for filing EEOC complaints.
Ms. Lewis, oh, I'm sorry. I thought you were done. My bad.
Yes, and retaliated against for exercising my human right to go and use the restroom.
Okay. Ms. Lewis, do you have any questions for Mr. Pope based on the questions I just asked?
I had a question, Your Honor. Just one. With regards to the EEOC complaints that you have filed, it is your understanding that none of them returned with any findings against MARTA, correct?
Other than right to sue letter, no. Other than right to sue letter,
Received your notice of right to sue
I received a notice of right to sue letter.
that made no findings of ill intent, employment discrimination against MARTA.
Well, they didn't send me no email. I don't know about Marta.
No, the question was, did the letter that you received, the right to sue letter from EEOC, did it contain any findings by EEOC that MARTA had done anything wrong? Or did it simply say, we're done here. If you want to sue, you have a right to sue? I'm paraphrasing, but you understand what I'm asking? Yeah. So was the letter more along the lines of, hey, we are not finding in your favor here, but if you want to sue, you have a right to sue?
Yes, I got from it. We're not finding in favor of Marta or you. However, you have a right to sue.
Okay, it was a finding in no directions. We make no finding, but if you want to sue, you have a right to sue.
Based on, I have a right to sue based on claim the findings that
Okay. Anything else, Ms. Lewis? All right. Mr. Pope, you can, I'm gonna have you stay right there because we have a few things we need to work through. We're gonna take our lunch break now, ladies and gentlemen. I'm gonna ask you to be back as close to 1:30 as you can. During this lunch break, it's fine to be together. You don't have to be with each other. Just don't talk about the case. No outside research. When you get back, we will figure out what's next in this case. There'll be a few things I need to talk about with the parties before I can bring you back out here. And then we'll do that as soon as possible. Any logistical questions? No? All right. Good luck. See you soon. All right, we need to break now. Ms. Niles, I think, has some of the exhibits because Mr. Pope had emailed them or e-filed them or something. But there were a few she couldn't get. I'm gonna have her come out here and get with you all to see which one she needs to get the hard copy of to make a copy of. So you, Ms. Lewis, end up with copies of all the exhibits that were admitted. During the lunch break, if you could please, Mr. Pope, make sure that you get all the originals back and together because I need them in one pile by the court reporter. They'll go back with the jury for deliberations. So they need to be available. When we come back, I'm gonna ask you if you've got any other witnesses you're gonna call. I think you don't, but if you do, you can let me know.
No, I don't have witnesses, but however, I want to enter publish more exhibits that I publish.
Okay, well, we'll talk about whether that's gonna happen when we come back from lunch. They're in evidence, so I don't know if you're gonna be able to do that, but they're certainly in evidence, and so the jurors will get them. But we'll talk about that after lunch.
No problem, sir.
And that would be then, you'd be if you do get to publish them, that'd be the last thing you're doing, and then you're resting?
Yes.
Okay.
Question. When you say into evidence, you mean that they'll be looking at them?
Correct.
Okay. All right. Thank you.
So what we'll probably do is talk about any motions you have before I adjourn back out. And we'll want to navigate that. So you should be ready with that if you've got any when we return. I'll come out as close to 1:30 as I can, but I'm running this meeting that starts in a minute or two. And we will take it up then. Okay?
Yes, sir.
So Ms. New and the party should be back, let's say 1:25. You're welcome to stay in here. You don't have to go anywhere. And you're welcome to leave your things here if you do step out for lunch, okay?
Yes, sir.
But remember the homework assignment of getting the exhibits together that were admitted so Ms. Niles can figure out which ones she needs to make copies of.
Okay. Thank you.
Thank you.
And what time you say be back?
1:25.
All right.
Ms. New, are you ready?
Yes, sir.
All right, we are back on the record. Case Management Committee meeting ran late, so I apologize to the jurors that can't hear me for starting a little bit late, but to you as well. Ms. Lewis, did you get copies of exhibits? You feel complete now?
I do.
Good. All right. Mr. Pope, when we broke for lunch, you said, wait, I'm not done testifying. I have some exhibits that I want to publish. And I explained to you that your exhibits, that list that I read into the record, they're all in evidence. And so the jurors will have those to see and hold and look at should they end up deliberating in the case. And the sense I got from you, but I don't know that we were necessarily on the record, was, oh, now that I understand that they'll have all those exhibits, I don't need to publish them. Is that correct? Or do you still want to put up on a screen one or more of the exhibits that you didn't already?
Oh, no, I'm okay. If the exhibits that was entered, as you said, they're gonna look over, and come up with a decision, then, yeah, I'm okay.
Okay, they've got what you think they need.
Oh, yes.
Okay, then Mr. Pope, do you have any other witnesses that you're going to call?
No
Do you have any other evidence that you want to present?
evidence. No.
Okay, so are you resting?
Resting, well, I wanted to speak about something that the council said, but,
Speak to me or speak to the jury?
speak to the jury.
Well, how would you be doing that in your closing argument, or this would?
Fine, I can do it in my closing argument. I just want to make sure it get out,
Tell me what it is.
Well, she stated that I got a promotion from bus to rail, and in reality, technically, it's not. Bus and rail is the same division. It's the same pay, whether you do bus or rail. So I just wanted to let it be clear to the jury that there was no promotion given to me during my time.
You're saying that's more of a lateral.
Yeah, it's just a lateral. It just, you want to go to bus, you want to rail, you come back. It's not a promotion.
Okay, and when you say that Ms. Lewis said that, she said that in her opening statement to the jury?
I don't know if it's an opening statement, but I know she said it.
Okay. Ms. Lewis, I don't recall that specifically, but would that have been something you said in your opening? Okay, all right. That's something you're free to address in your closing, okay?
Yes.
All right. So other than that, which would be something that you would argue in your closing, do you have any other evidence you want to present, or are you resting?
I'm resting.
Okay. I'll have Mr. Pope do that in front of the jury in a little bit, Ms. Lewis, but since they're out in the jury room right now, I'd like to turn to whether the defense has any motions now that Mr. Pope has rested.
Motion for direct verdict as to all claims.
Okay. Why don't you come to the podium and explain to me and Mr. Pope what the basis for the directed verdict is.
Your Honor, if I may proceed by paragraphs in the amended complaint.
Okay, let me get that in front of me, please. All right, I've got it.
I'll begin with paragraph 4 of the amended complaint, Your Honor.
Okay.
Particular paragraph relates to an EEOC charge that, as plaintiff testified to, ended in 05796. The notice of right to sue for that particular charge was issued on April 5th, 2023. And there was a 90-day window wherein plaintiff was able to file suit. That 90-day window expired on July 5th, 2023. And as the court has already taken judicial notice of, the complaint was filed September 28th, 2023, more than 2 months post the deadline.
Someone's phone is unhappy.
It's my MARTA cell phone. Everybody is calling.
Uh-oh.
Wondering where I am.
They should know you're in trial.
Should know that. So as the law would have it 42 USCA section 2000E-5. Plaintiff is barred from asserting any claim with regards to that particular charge. And that would relate to his claims in paragraph 4 of his amended complaint.
Do you have Georgia case law that applies the Title 42 bar?
One second, Your Honor. I have not cited any Georgia case law applying the title, did you say Title 42, Your Honor?
That's what you cited to me. You said it was 42 US Code 2000E-5.
That's correct.
And I don't have that provision in front of me, but I trust it says what you said it says, but it's peculiar that a federal statute can say you can't sue in state court. And I trust that's what it says, but, or maybe you just can't sue at all. It doesn't tell you where. And I'm wondering if you, in the course of your work, have encountered Georgia cases that apply it and say, hey, this lawsuit is out of time because of this federal statute.
Your Honor, and I'm going to pull these up as I cite them to you. Doss v. City of Savannah, 290 Georgia App, 670, 2008. That
670?
Yes, sir.
Okay.
670. Outlining the process that requires Title VII charges must be filed with the EEOC and that the EEOC must issue a right to sue letter before the individual can bring a civil action in court. That is also another case, Collins versus Department of Transportation, 208 Georgia App 53, 1993 case. It's still good law. It requires that plaintiffs exhaust all administrative remedies with the EEOC before pursuing legal action in court for employment discrimination claims under Title VII.
Okay, but Mr. Pope clearly did that. He went through the EEOC, he got his right to sue letter, and then you're saying there's this statutory provision that says you've got 90 days or else. And I don't know that either of those cases tackles that, but.
I believe Savannah may address the outlining of the process more specifically, whereas Collins more specifically holds that the exhaustion of administrative remedies prior to filing suit. But,
okay.
The federal law would, I think, trump what we would say in Georgia either way. The notice of right to sue very clearly lays that timeline out. And that is a part of them exhausting their administrative remedies that they comply with.
Okay, well, let's keep going through the timeline that you've identified, and we'll see what the case law says in terms of applying this right to sue 90-day window. So paragraph 4, if there is a bar, it is time barred. The claims set forth in paragraph 4. What's next?
Paragraphs 3, 6, 7, 8, and 9.
3, 6, 7, and 6 through 9. Okay.
Your Honor, with regards to these, there were no EEOC charges filed at all. And so those two cases I just cited as well are applicable there, with outlining the requirement for the exhaustion of administrative remedies prior to filing legal action in court. And the policy behind that, Your Honor, is that employers be given a chance to address any wrongful action or allegations of wrongful action, and that they be given a chance to remedy that with the employee. There's a complete process through the EEOC where there's mediation. All of these charges are addressed and an investigation is done.
And that happened with the retaliation claim set forth in paragraph 4. Mr. Pope brought the allegations to the EEOC, and they took all the steps that you're describing, and ultimately their conclusion was, we're not finding for either side. But certainly now, having done what you did, Mr. Pope, taking the steps you took, you have a right to sue. And for him, that was Fulton Superior Court.
That was Fulton Superior Court, and I just want to be clear on his allegation was based on sex and age, that he was retaliated against when he was written up for failure to follow instructions in January 2021. And that was with regards to paragraph 4.
Okay.
I just wanted to be clear on what he alleged happened, and that's what he filed the EEOC for. I know he threw in a lot of other actions that were not included in the EEOC.
Okay, but he got the right to sue over the incident underlying the alleged retaliation because he went through the EEOC process, and their final conclusion was not, MARTA, you were wrong, or Mr. Pope, this is unfounded. It's, all right, we're granting you the right to sue. And then your argument is he exercised that too late.
Exactly.
And for all the other paragraphs.
There were no EEOC charges filed.
Okay.
And he admitted that on the stand today.
Okay, which means, according to one of the cases you cited, he failed, well, I guess he failed to exhaust his federal administrative remedies, and so the local courts are not open for business for those kinds of claims.
He's barred, yes.
Okay. I noticed you didn't include paragraph 10.
One second, I'll tell you why.
And that may simply be what you would call his prayer for relief.
Yes, Your Honor.
As a pro se litigant, he's not expected to label things the way that you might as an attorney. But that might be why you're not including.
That is why.
Okay.
And the only other paragraph we have not addressed is paragraph 5.
3, yes, that's right. And what about paragraph 5?
This particular paragraph, I just want to go back over the allegations. The plaintiff alleged that the MARTA rail managerial team has a history of violating his civil rights with regards to OSHA, as well as, I'm so sorry.
Well, it's not so much that the history, what paragraph 5 says.
Read the wrong paragraph, Your Honor.
Yeah.
It was denied a relief break.
Exactly. So at a specific date, October 2022, he was denied, I think this is the emergency relief we heard about.
Correct, that is correct.
And he says that Mr. Bell, who is a rail tower supervisor, violated Mr. Pope's civil rights, OSHA rights, et cetera. So what precludes paragraph 5 from going to the jury?
He has failed to make out a prima facie case of race or gender discrimination based on the evidence that has been presented. In order to establish this claim, there's a McDonnell-Douglas analysis. Of course, the court is well aware.
I'm not well aware.
Oh, okay. Well, I'll explain. He has to establish that he is a member of a protected class. He has to establish that he suffered an adverse employment action. He has to establish that his employer treated similarly situated employees outside of his class more favorably, and that he was qualified to do the job. This is a burden shifting analysis, and it's 3 parts. So if the charging party can establish the prima facie case through circumstantial evidence, then MARTA would have the burden to establish a non-discriminatory reason for its actions. Once we have articulated that, then the employee must prove that MARTA's reason was pretext to the discrimination. So here in this case, Your Honor, the plaintiff has done nothing to establish that he is a member of a protected class. The jurors don't know what his age was at the time of this alleged discrimination. He didn't establish what particular class he fell under. Even after the jurors asked in particular, well, what makes this an age case? And I think paragraph 5 speaks to civil rights and his rights under OSHA that were violated when he was denied a relief break. Nothing about that clarifies for the jury, gives them enough evidence to be able to establish that he was a member of a protected class. The second element, he suffered an adverse employment action. No adverse employment action has been established. And Your Honor, that is a termination, a demotion, something that was lost, that was not restored with regards to his employment. None of that has been established via his testimony with regards to paragraph 5.
So I'm not remembering all the specifics of Mr. Pope's testimony and his exhibits, but I thought he was suspended for 3 days and that maybe I'm mixing up the different, I guess it was your radio wasn't working, was when he had 2 different 3-day suspensions, one of which got cleared up and his time was given back, but that was not based on the emergency relief.
No.
And then the other one was something about the radio not working
Paragraph 9.
and that one was the one that generated that email saying you better stay off the property and MARTA police will escort you off the property. But I don't think there's anything in the record where MARTA said, whoa, we made a mistake. You get your days back.
That is in no way connected in time or relevance to what is alleged in paragraph 5 in the EEOC charge that was filed with regards to that.
There was no EEOC filed in connection with paragraph 5.
There was.
Oh, when was that? What is the timeline for that? Why is 5 not excluded for the 90-day window reason?
Because he filed suit within the 90-day window from issuance of the notice of right to sue for paragraph 5, Your Honor.
Got it.
It was 3, 6, 7, 8, and 9 that he filed no EEOC at all. And then 4 where he did, but he filed suit after the limitation had expired.
So there are 2 EEOC actions that are germane to the complaint. One that ends in, you gave me the numbers, but
796.
796, that's right. And then what are the last 3 digits of the one related to the emergency relief?
Paragraph 5 is 1 second. Okay, it would be 00108.
108. Okay, so that one, 108 resulted in another right to sue letter, and Mr. Pope's original complaint in this case was filed within 90 days of the issuance of that.
That's correct.
Okay.
So our argument as to paragraph 5, Your Honor, is not one that is based on a statute of limitations. It's just that the claim is not viable in and of itself. It does not constitute, or as the evidence has been laid out today, it would not constitute a prima facie case for unlawful age discrimination or retaliation.
Okay.
And that was the McDonnell-Douglas analysis. And then with regards to retaliation, the prima facie case of retaliation must be demonstrated by the plaintiff showing that he, 1, engaged in a statutorily protected activity, and 2, that he suffered a materially adverse employment action, and 3, a causal relationship between the 2 events exists. Again, as it relates to paragraph 5 only, not considering any suspensions or anything, because he was not suspended with regards to paragraph 5. There was no proof testimony with regards to him engaging in a statutorily protected activity. He did not suffer any materially adverse employment action. With regards to paragraph 5, the only thing he did establish is that there was a report that was written up for his failure to take relief pursuant to the order, the general order. And then he also did not establish a causal relationship between the two, between the adverse employment activity and the statutorily protected activity, because they didn't exist. So our motion would be, as to all claims as alleged, we believe there's insufficient evidence for the jury to go back to deliberate with regards to these, because plaintiff has failed to meet his prima facie case as to all.
All right. Do you have a more precise citation to Title 42? 42 USC 2000E-5 is very long, and I'm curious where this 90-day window is.
Do it a lot quicker if I had the notice of right to sue out readily. Let's see. Okay. Is that? Thank you. One second, Your Honor. Pull up my handy dandy Lexus. E5, is it? I think it's F1. Let me pull that up. Charging party may choose to file a private civil action upon receipt of the dismissal notice, but must do so within 90 days.
Where F1 is, where is that in F1 is almost a screen full of text.
Let me see. Okay, so how do I tell you where this is? Let's see. Okay, so there's a sentence, the person agreed as a party, the commission or the attorney general.
I think I found it, but let me
Okay.
read. This sentence is
Sure.
about 10 lines long.
Mm-hmm.
Because it doesn't say anything about a right to sue letter, but I guess that's what it's called. It says that if a charge filed with the commission is dismissed, or the commission hasn't filed a civil action,
Within
or they haven't entered a conciliation agreement, then the commission notifies the person aggrieved, that's Mr. Pope, and within 90 days after giving such notice, a civil action may be brought against the respondent, that would be you, MARTA, Okay, so that's the 90-day window.
Yes, and I have a copy of one of the notice of rights to sues. It very clearly, it makes that part bold because it stand out. It's a restriction, so they make sure it stands out.
Okay,
They embolden that on the notice of right to sue.
okay. All right, anything else?
I think that's it, Your Honor. I think we've addressed all of the applicable paragraphs, and I just ask that you grant the motion.
Okay, so Mr. Pope, Ms. Lewis is arguing that I resolve your case now in MARTA's favor, take it from the jury and enter what's called a directed verdict in favor of MARTA for different reasons depending on the paragraphs we're dealing with. For paragraph 4, the argument is you missed a deadline, this 90-day window to sue. For paragraph 5, it's sort of a variety of arguments, but basically you didn't present any evidence to the jury as to how action that Supervisor Bell took in October of 22 was discriminatory on the basis of either gender or age. And then for all those other paragraphs, it was because you didn't file an EEOC charge concerning those alleged violations of your employment rights. So you can respond in whatever order you want. I'm just letting you know it's a different argument for different paragraphs.
Oh, okay. I came down to Fulton County and filed an amendment complaint to my original charges that she referring to.
I don't think that we're working off the dates in the amended complaint, but Ms. Lewis has given you the benefit of your original complaint date, which we know was late September. So you first came in here and said, here's Pope versus MARTA, and it was assigned to me in September of 23. And she's pointing out that that is outside the 90-day window that you had to file suit. For paragraph 4 only, it was inside the window for paragraph 5. And then for all those other paragraphs, there was never an EEOC complaint or whatever the term would be. And so you actually shouldn't be suing yet because you didn't exhaust your EEOC remedies.
So you assuming that I have to file an EEOC complaint before I file a suit?
I'm not saying anything. Ms. Lewis is saying that the case law is that you need to file an EEOC complaint before you can sue an employer in state or federal court for employment discrimination on whatever grounds. Yours is age and gender, but that you're supposed to start with EEOC. And I think that was the 208 Georgia appeals case. You say it stands for that proposition? Okay. So you're free to say she's wrong. You can say here's a case that shows she's wrong. I just want to give you a chance. I got to go read the cases, but I want to give you a chance to make your argument. So I hear that before I go back into my office and do a little research.
Oh, okay. Well, I filed EEOC complaints. I have like 3 over here.
Well, they're not in evidence, so I don't know what you did or didn't do. What is in evidence is that you filed a EEOC complaint in connection with the paragraph 4, where the radio situation, and that one, you didn't file your lawsuit within 90 days of getting your right to sue letter. Paragraph 5, which was the emergency relief situation, you did file an EEOC complaint and you filed your lawsuit within that 90-day window. But for all the others, there's nothing in the evidence now, and your evidence is closed. You don't get to introduce any more evidence. There's nothing in the record that you filed an EEOC complaint, for example, about you being suspended by Superintendent Brown for refusing to sign an attendance form. Maybe you did file an EEOC complaint, but I can't consider that one because it's not in the record.
Okay, what about number 3? It's not in the record?
I don't think there's any EEOC complaint that's actually in the record, like the complaint. So what we've got in the record would be testimony, things you said, that's also evidence. And you answered a bunch of questions when Ms. Lewis was cross-examining you. And she explored with you 2 EEOC complaints. One of them ends in 796, that relates to paragraph 4. And the other ends in 108, and that relates to paragraph 5. There's no evidence, Ms. Lewis is contending, of any other EEOC complaints that are in the record. So that's our starting point. Now, if you think you testified about others and you named them with specificity and gave dates of when they were filed and when you got your right to sue letter, you can tell me about that. I don't remember that testimony.
Okay, what I'm asking is number 3.
Paragraph 3?
Paragraph 3 that she said this.
I'm looking at paragraph 3. She says there's no EEOC complaint or charge in evidence in connection with paragraph 3.
So for the record, I filed my lawsuit September 27, 2020, September 23, 2023.
Okay.
Yeah, and she's insinuating that my amendment complaint, paragraph 3 is not in that, from my understanding.
Is not in your original complaint?
No, my amendment complaint.
Repeat what you said. I'm sorry, I didn't follow you.
My amendment complaint, the one paragraph 3.
Yeah.
Amendment complaint.
What about it?
The lawsuit that I filed, she's saying that that's not, paragraph 3 doesn't have anything to do with that lawsuit.
No, that's not what she's saying. And your lawsuit is now the amended complaint. Your original complaint, you've amended. So paragraph 3 is part of your lawsuit. What I heard Ms. Lewis say is that paragraph 3 is not the subject of any EEOC charge that you brought. She's not saying you filed your lawsuit too late as to paragraph 3 or outside the 90-day window. She is saying there is no 90-day window because there's no evidence in front of Judge McBurney that Mr. Pope complained to EEOC about having been discriminated against and passed up on promotion to journeyman ET radio maintenance. That maybe that happened, but that's not something that you complained to the EEOC about. And because you didn't, you are prevented from suing. You got to go EEOC first, get your answer, and the answer is you win, you lose, or right to sue. And if it's right to sue, then you could bring paragraph 3. That's how I'm understanding her argument. I want to know your response to that.
I mean, I disagree. I mean, it's how you understand her argument, but I mean.
Tell me what part are you disagreeing that are you saying I don't need to go to EEOC first, or are you saying you did go to EEOC, or you're saying she's mistaken about what?
Oh no, I'm saying that whatever she got to the podium and said, That's something that I have to go do my research on. But as of right now, I don't know, based on what she said.
Okay, so I have to do a little research, and that's what's gonna govern how I manage this. But you don't have in front of you cases that say Ms. Lewis's argument is incorrect. Is that right?
Well, I have to check, look at my documents.
Okay, I'll let you do that, because I'm gonna need to go do a little research.
Okay.
Anything else you wanna share with me, in response to Ms. Lewis's 3 arguments?
Not right now, sir. I don't have anything right now
Okay,
at the moment.
all right, Ms. Lewis,
Yes,
did you find me more cases?
I have some cases, citations,
Great,
paragraph 5. In particular, with regards to the standard by which age discrimination has to be established, 498 F third 9. let's see. It's at 15, page 15, and that's a 2007 case. I wanted to give you more on the McDonnell Douglas analysis if you know.
well, I don't know that you need to right now because your argument is in effect that no evidence was presented that gender or age played a role in the action that Bell took. And so that's a sufficiency of the record issue, as opposed to what's the test. I'm more interested in cases that say 90 days means 90, and if you file outside that. I found, I think, a few federal cases, but I need to go back into my office and read those. Did you have anything else?
Not with regards to that particular point, Your Honor. I
Okay,
have those 2 that I cited, Dobbs v. City of Savannah and Collins versus Department of Transportation.
okay. All right, thank you. Deputy Gordon, if you would let the jurors know that we are working hard on a few legal issues. We have not forgotten about them and they should be at ease. Okay. I gotta go do a little research, and I will come back to see if either of you wants to add anything to the discussion. Let me ask this last question. Would I find case law in your motion for summary judgment, or you are citing to me now what you cited in your motion for summary judgment? I should say different or additional case law.
It should be, it might be the same, Your Honor.
Okay. How about this? I'm gonna go do some research. Please look at your motion, and if there are other cases, email those citations to Mr. Pope and to me.
Oh, yes, Your Honor, I'll do that.
Thanks.
The 90-day window of time, or is it as to any of the claims that, or any of the arguments that I've made today with regards to the motion for direction?
Any of the 3. Thanks. Okay, Ms. New, are you ready? We are back on the record. Ms. Lewis, you are moving. You've moved for a directed verdict. Is there anything more you want to add? I did receive an email that I think you also sent to Mr. Pope that listed additional case law in support of your argument. Beyond that, anything you want to add? Okay. Mr. Pope, you've had the same break as everyone else. Is there anything you want to add in terms of your response to Ms. Lewis's motion?
Well, it's ridiculous. I mean, if I may speak, this trial almost close to 2 years. I came before you on, I don't remember what date it was, and got my lawsuit amended. This is a attorney, she licensed attorney, and for this to drag out so long and easy, she's filed this before, and trying to get it, I guess, overturned or whatever the case is, but it just, I don't understand, you know. I mean, if I'm an attorney, if I'm a judge or attorney, you know, I'm gonna cut this loose. I'm not gonna drag that out just to say, hey, you didn't file at the right time. I mean, you guys get paid to do this. So this is really
It's frustrating.
well, not so bit frustrating, just embarrassing for this not just me, it's embarrassing for the law, the courts. I mean, you guys know the laws. Pro se. I'm not making no excuses or anything, but
You don't need to make
still,
any
you know,
excuses.
I mean, I still disagree with her motion, so
Okay.
I hear from you, but
All right. Well, let me start by addressing your comments you just made. I think they are well put, and I agree with you. This is a case that I think could have been resolved through filings rather than a trial a while ago on technical grounds. That's what I'm going to end up ruling here is mostly on technical or procedural grounds. And in a very feeble and intentionally so defense of MARTA's handling of this, they made those arguments in the motion for summary judgment, but that was too late. There was a deadline in this case for a motion for summary judgment. I don't know why MARTA missed it. That is not anything I can control. But one thing I'll tell you, Mr. Pope, is that I'm not authorized to, on my own, look at a case and say, this is barred by a procedural statute of limitations, and this is a bad claim, and this is a good claim. I might know that that's legally the correct ruling, but one side or the other needs to say, Judge, we're asking you to do this. Otherwise, judges could just look at a lawsuit when it's filed and say, I don't like this, and toss it out. And that wouldn't be correct, wouldn't be fair, wouldn't be due process to either side. You are correct that some of the reasons why I'm going to rule the way I'm going to rule have been true since you filed your lawsuit, and they are only now being brought to me in a timely way, if you will, to rule on. It's perfectly appropriate to make the arguments that Ms. Lewis is making now because we got to trial, but we probably didn't need to get to trial if everyone had been up to speed on the case. But here we are. I mean, we're here. I need to rule on the motion that's been made, and I'm going to break it down into the individual pieces.
I'm sorry, there's a record that has been made with regards to, I guess, competency and proceeding with this case. I just want to address that very briefly, Your Honor.
Well, I want to be clear. I haven't, nothing I've said has been, should be construed as me saying anyone being competent. You have a huge caseload. My observation was, I think there were opportunities for us to tackle this case in the way we're tackling it now, that were missed. That's not a competency, that's a workload issue.
That wasn't a reflection of your comments, more so Mr. Pope's, but if I could, briefly, Your Honor, address that. On the day of trial, when this case was first noticed for trial, plaintiff filed an amended charge. Well, his first charge or complaint in this case had 2 sentences. There was nothing for me to go off of. When he refiled the amended complaint, there were an additional 10 paragraphs, a lot of which we had to sort through and figure out what he meant. When sorting through that, we realized that he had filed EEOC charges that MARTA had never been noticed of, and that MARTA had no proof that had resolved. And so we had to rely a lot on the EEOC in establishing what he had found and what exactly he had alleged, because that has a lot to do with a dispositive motion in this case. And unfortunately, there was not a quick response from the EEOC in regards to what happened. So when he says that I'm a lawyer, I am licensed, I should know the law, I do. A lot of that does not depend on what I know or what I'm capable of doing. It depends a lot of times on the responses that we get. So I just want to make that clear. We have not belated in this case at all. We filed discovery timely, we responded timely. There was a mix up in timeliness of his filing because he filed the same request twice. That was it. But as far as responding and making the case for MARTA, I think we did the best we could with what we had to go off of.
Okay, those are all fair points. And you are a lawyer, not a magician. And you don't get a wave a wand and EEOC files land in your lap. So I appreciate you flagging that. And as I was in the midst of saying, we are where we are now. We are in trial. You've rested. We'll get you to rest in front of the jury in a minute. But you resting triggers the defense's opportunity to make a motion for a directed verdict. And if I conclude that it's appropriate to grant a directed verdict, I should do that. It's a pretty steep hill that the defense needs to climb, because they are asking me to take the case from the jury and decide it myself. In fact, the standard is that it should only be granted if there is no conflict in the evidence as to any material issue to your claims, and if the evidence that has been introduced, if we treat it reasonably, demands a particular verdict. That's the test that is commonly pronounced. That applies more to the sufficiency of the evidence. I think we have some procedural bars here that apply as well, which I think is triggered in part. You're not frustrated. You're saying you're embarrassed for the court and for MARTA's lawyers. Things that, in theory, if we knew everything about your situation, could have been argued earlier. But much as I'm agreeing with some of what you're saying, I'm agreeing with some of what Ms. Lewis is saying, which is that your approach, because you have elected to proceed on your own, has been a little scattershot, and you are trying to cover the bases as best you can see and as best you understand them. But that's been manifested by an exhibit list that goes to 108, and then all of a sudden we're talking about exhibits that are 1Z6 and S10 and letters and numbers. And so I think it's fair pushback from Ms. Lewis to say, it was kind of hard for me to tell what exactly I'm up against. Had you had a lawyer, that lawyer would have pledged your case A, B, C, D, crisp, crisp, crisp. And then Ms. Lewis could say, here's why that doesn't work. Here's my motion. Oh, this one works. We got to go forward on that one. And nope, I'm done hearing from the two sides. I'm going to talk for a little longer. So we're working with your complaint, amended complaint as drafted. That's the universe that you pled. Paragraphs 3 and 6 through 9 all relate to conduct for which there is no evidence before this jury that an EEOC complaint was ever filed. In order for you, Mr. Pope, to bring into state court, into Superior Court of Georgia, any claim pursuant to Title VII, discrimination on the basis of age, on the basis of gender, and those are your two bases, you must first file a charge with the EEOC. And the proposition, the support for that is first, the federal statute, 42 USC 2000 lowercase e 5, subsection E, but also DOSS versus City of Savannah, 290 Georgia Appeals 670 at 675. That is a threshold requirement. If you're going to bring an employment discrimination claim in a Georgia court, you start by first administratively pursuing that with the EEOC. And I find that there is no evidence in the record before the jury that you did that in connection with 3, 6, 7, 8, and 9. As to paragraph 4, you did pursue things with the EEOC, and that's their case number that ends in 796. And you received a right to sue letter that was issued on April 5th of 2023. You've testified to that effect. That right to sue letter very clearly gave you a 90-day window in which to bring your lawsuit. Your initial lawsuit, not the amended complaint, your initial lawsuit was not filed within that 90-day window. Obviously, your amended complaint was filed even later, but it's your first one that would stop that 90-day clock. But it was filed a couple months after that deadline had expired. In Collins versus the Department of Transportation, 208 Georgia Appeals 53 at page 56, our Court of Appeals said that in order for superior courts in Georgia to have subject matter jurisdiction, there must be a timely claim brought here pursuant to the EEOC notification that you can file a suit. That's that 90-day clock. And timely means within 90 days. More specifically, in Surrell, SURRELL versus California Water Services Corporation, which is at 518 F3rd 1097 at page 1104. That's a Ninth Circuit case. The Ninth Circuit Court of Appeals stated very plainly, once a person receives an EEOC right to sue letter, she has 90 days to file suit, period. Full stop. And the allegations in paragraph 4 were not brought to court within that 90-day window. So I'm directing a verdict as to paragraph 4. Paragraph 5, you did file a different EEOC complaint. It ends in 108, and you did bring your original complaint within that 90-day window. And so that was timely filed, but I find as to paragraph 5, as well as to any other relief for which you timely brought suit, and that relief all relates to your overarching allegation, which is that you were denied either advancement, meaning promotion, or raises, compensation, at MARTA on the basis of gender and or age. So any claim that was timely asserted that you were discriminated against on the basis of your age and or your gender, that those are not adequately supported by the evidence that you admitted during your case in chief. In order for you to survive a motion for a directed verdict, you must have made this preliminary case that you were a member of a protected class, male, you're a member of a gender. You haven't established what the age differential was between you and someone who either got paid more than you and was promoted. Was it 1 year or 10 years or 20 years? You haven't established specifically who was considered for whatever promotion you sought, and that person's gender and age. There was a general claim by you when you were testifying that younger females got advancements that you didn't, but not a definition of what younger means or frankly who those people were. Nor did you make any showing that these people were less qualified than you for the promotion or the raise. And that covers all of those allegations that may have been timely filed. I find that the record before this jury would not enable them to reasonably and rationally, based on this record, if Ms. Lewis simply said MARTA rests, for the jury to say, yes, we conclude that Mr. Pope has shown by a preponderance of the evidence that these other people who got promotions or got raises were younger, were a different gender, were less qualified, and here's how much younger they were, different gender, just as different gender, but that they were either just as qualified, and so the only explanation could be gender or race, or they were less qualified, and so they ought not to have received that promotion or that raise over Mr. Pope. Absent that kind of evidence, it's inappropriate for the case to go to the jury, or said conversely, it's appropriate to grant the motion for a directed verdict, which is what I will do when the jurors come back out here. Ms. Lewis, is there anything else you want to get on the record? Mr. Pope, is there anything else you want to get on the record before the jurors come in?
Oh, no, sir.
Okay. One last thing, when the jurors come back out, I'm going to ask you, Mr. Pope, if you have any other evidence or if you're going to rest. I assume you're going to say rest. That's what you told me. Then I'm going to tell the jury what we've been working on. I'm going to have the jurors go back into the jury room. I'm going to thank them for their service. And then they may be willing to interact with you all if you want to ask them any questions about anything. I'm just letting you know, you may want to stick around in case they want to come out and give feedback. They're not obligated to do that. They may all say, we'd like to leave. But if you know you don't want to interact with them, I don't want to ask them to come out here if they're interested. Mr. Pope, are you interested in that at all?
Oh, no, sir.
Okay. Ms. Lewis?
Sure, Your Honor.
Okay. Well, we'll see if they are interested. Pardon me?
Only if they're interested.
Right. No, that's always the ultimate threshold. But if neither side was, then I don't even broach it with them. Okay. Let's bring the jurors out, please.
Rise from jurors. Jurors are present, you count for?
Welcome back, ladies and gentlemen. Thank you for indulging us as we worked through a number of issues that we had to tackle. Mr. Pope, before we broke for lunch, we were going to work through making sure we had the exhibits all in one place. And then you were going to let everyone know if you had more witnesses to call or if you were resting.
Oh, yes, resting.
You're resting. Okay. Ladies and gentlemen, during the break, both the lunch break and your extended bonus break after lunch, we took up the legal process that occurs after a plaintiff rests in a civil case. One thing that a civil defendant can do at the close of a plaintiff's case is move for what's called a directed verdict. That's when the defense says, Judge, based on the record that's been made by the party that had the burden of proof, we think that you should rule in our favor. In other words, the case does not go to a jury to deliberate because either there is a procedural bar or the evidence is such that it would not be rational for a jury to come down with a verdict in favor of the plaintiff because either the evidence is too conflicting or it's insufficient. That's an argument that Ms. Lewis made. Mr. Pope argued in response. I had to do a bunch of legal research because it involved employment law. And it turns out that it's not common to do employment law cases in state court. It usually happens in federal court. So I learned a bunch of federal law as well. But I have ruled in favor of the motion for directed verdict, which means the case is now closed. I have entered orally, or I am now entering orally, judgment in favor of MARTA, and your jury duty is complete. I know you only heard half the story, and that may seem like not how the process is supposed to work, especially since in one of my mini sermons yesterday, I said, when there are intractable disputes, we turn to members of the community, U13, to resolve those disputes. But there are some guardrails in place so that we don't send you to deliberate when the evidence doesn't justify deliberations. And that is what we ran into in this case. So on behalf of Mr. Pope, as well as MARTA, I want to thank you for your service and your time. In just a moment, you're going to go with Deputy Gordon back to the jury room. I'm going to come back there to thank you again, get you letters that provide proof of service, answer any questions you have, and give you your final operating instructions. Okay? So if you grab your notepads, head to the jury room. I will be there in a second.
All right, for the jury.
Okay, all right.
Go back and I'll take them. Thanks. I'll give them to you. Mr. Pope,
Yes, sir.
anything else you want to get on the record?
Oh, no, sir.
Pardon me? I want to thank you for your preparation and your professionalism. I will tell you going in, I was a little nervous because I've had pro se trials before, and sometimes the self-represented litigants get frustrated, and then they sort of take that out on the jury or this or that. And you were calm and poised and as organized as you could be expected to be as a non-lawyer. And so I want to tell you, what's your official title? Are you a rail operator?
Yes, sir.
You are the best rail operator, non-lawyer attorney that I've had in here. So I want to thank you for that. You are justified in leaving here feeling disappointed and frustrated, but it's not because you didn't try. And I want you to know it's not because in any way I treated you differently because you were representing yourself. I worked hard to treat you with the same respect as I treated Ms. Lewis. And the rulings I made had nothing to do with you being a non-lawyer and everything to do with my understanding of what the law requires. I didn't know there was a 90-day rule that if you get a right to sue letter, although it says it in the letter, you got to sue within the 90 days. But the law is very clear about that. And so I need to apply that. And so this is not a Judge McBurney that, well, Mr. Pope's a non-lawyer, so let's railroad him. Not at all. You were very sincere and passionate in what you were litigating. And there may be other avenues of relief for you, and you may want to apply to law school. You should think about that. But I want to commend you for your professionalism in this because pro se litigants don't always handle it in the same way that you've handled it. So thank you for that.
All right, no problem. Thank you.
All right. Ms. Lewis, I want to thank you. You worked with Mr. Pope in a exceptionally professional way, in the same way that some pro se litigants don't always comport themselves here when things don't go well. I have had lawyers who exploit the fact that there is a non-lawyer on the other side. And that's not how you did this at all. You were very patient and understood why things might take longer and rolled with it when I might have indulged Mr. Pope more than I would have Attorney Pope representing someone suing MARTA. So you are to be commended for your patience and perseverance in this and for powering through as you recover from whatever ick that you had. So thank you for that. I will check with the jurors to see if anyone wants to say stay. And I won't leave you hanging out here. If they all take off, Deputy Gordon and I will poke our heads out to say, here's the situation. Okay? All right. You need to make sure you settle up with Ms. New.
I will make sure she's good. Your Honor, I'll also be followed tonight, now that I know my time. Motion for attorney's fee to ask the court consider that. We need a hearing on it.
Okay. We'll work through whatever gets filed.
Thank you.
All right.
Y'all have a great day.
All right. Take care. All right. Well, thank you, everyone.
Thank you. You're hoping my last trial.
No more trials? In-house doesn't do trials?
Yes, but I'm hoping I do something else in-house, not like this.
Oh.
So. Do you have everything you need from me?
I do, I sent the information that I got this morning. They've already created a job number and everything, so